were 41. 5 of them were very essential and indispensable. Now, one of them, the chairman, was the requirement of the company PDS to produce what we call security. And the security was later on determined to be a demand guarantee from an insurance company for the transfer of assets to the chairman. A date 1st March 2019, from memory serves right, was set as the date for transfer of the assets. On 27 February 2019, PDS finished what purported to be a demand guarantee from an insurance firm described as Output Insurance of Qatar. The chairman, ECG sought to confirm the authenticity and validity of the demand guarantee. Because of the constraint of time, ECG actually indicated to PDS that it was going to confirm the demand guarantee in form, but not in substance, and reserve the right to conduct further processes or investigations to ascertain the validity of the demand guarantees. The chairman, a letter dated, and once again I have some documents that effect. Chairman, a letter was written by ECG to Output.
Chairman, we appreciate that the nominee is detailed, but you see in your answer you said condition precedent.
Yes.
What our honorable colleague wants to know, what informed the abrogation? As I understand.
The termination.
Yes.
The
termination, sorry, the termination.
Yes, that's what I'm alluding to. But the termination was informed by
Appreciated.
failure of the demand guarantee.
Okay.
And therefore must, with all respect, take just about 5 minutes to explain. So the letter was written by ECG, dated 28 February 2018 to Output Insurance. And it sought to confirm the demand guarantee. No reply was elicited from Output Company. And then ECG wrote another letter dated 15th March, again to Output Insurance. No reply was elicited. The chairman, on 13th March 2018, Output purported to confirm the demand guarantee. And it says, the chairman, but the letter confirming it, dated 13 March 2018. The letter is here. I just find a little print to read. The chairman, ECG appeared not to be satisfied with the confirmation or purported confirmation by Output, because the letter was on the face of it signed by a middle-ranking officer of Output branch. ECG got in touch with our mission in Qatar to physically ascertain from the offices of Output whether such letter has been issued. And then, surprisingly, the chairman, in the course of it, by letter dated 16 July 2019, Output wrote through its chief executive denying issuing any demand guarantee at all. Output further indicated that it did not even have the capacity to issue such demand guarantees. Further, the officer in question had forged the earlier letter purporting to confirm the demand guarantee. Also, as per the laws of Qatar, Output could not even have issued such a guarantee because it required confirmation by the Central Bank of Qatar. This indeed took the president by surprise. The president thus constituted a team to go to Qatar to ascertain the truth of all these matters. The team was led by the Minister for Interior, then Mr. Mbuzeri, had myself as a member, had other members of the Ghana, had some members of the Ghana Police Service also as members, lawyers in Ghana. Indeed, we met all the top executive of Alvin Insurance, the chief executive officer, their lawyers, and we also met their chairman. They confirmed the truth of all the matters contained in their letter repudiating the demand guarantees. And that's our report confirms all these matters. They further confirmed that the officer in question had, by a letter dated 21st July 2019, been suspended without any pay at all. The president was very concerned because assets of the nation worth about $3 billion were at stake. And therefore, if there had been a failure of an essential condition precedent, which more or less had the effect of guaranteeing the transfer of the assets of ECG, then action had to be taken promptly. ECG suspended the lease assignment agreement as well as the bulk supply agreement. And then the Ministry of Finance suspended the agreement and executed with PDS. And that was to pave way for further investigations. Indeed, the government of Ghana went beyond it and took the steps of engaging the Millennium Challenge Corporation in the United States of America. And that delegation was dispatched by the president, led by the Minister for Foreign Affairs and the Minister for Finance, and I was also a member, and other persons, members of government also passed the team. The chairman, our point was just simple, to ensure that the assets of the country will be properly protected and nothing else. In the course of time, the Millennium Challenge Corporation itself had also conducted their own investigations. The chairman, and the report was by an entity called FTI Consulting, dated 30th August 2019. And the report, with all respect, made for very interesting reading. And they indicated at page 19, so the font size is very small, that's why sometimes I strike, I'm sorry, that real authority, that based on our review of the document, output does not seem, that Mr. Nuri is a gentleman, the rogue gentleman who had executed all those documents on behalf of our group. It does not seem that Mr. Nuri was authorized to execute the guarantees, although the technical document authority list includes Mr. Nuri as an authorized signatory to technical documents. It fails to define or detail what is meant by a technical document. Then it further went on to say that while there was no provisions in local law that set out the concept and doctrine of apparent authority. So the FTI company went ahead to make the finding that even though the gentleman who had signed the letters on the basis of which the demand guarantees had been allegedly issued by output did not have real authority, under the laws of Qatar, the government of Ghana could proceed against the insurance company in Qatar on the doctrine of what is called apparent authority. And that apparent authority was per the decision of the court of Qatar. The chairman, the alternative to all of this was that the courts of Qatar do not apply the doctrine of stare decisis. They do not. Secondly, it would also have been, with all respect, a little bit incongruous and irresponsible for the government of Ghana to proceed all the way to Qatar to engage in litigation to confirm the validity of a demand guarantee based on a decision of a court of Qatar which was not binding on the court of Qatar. In the face of all of this, after about 3 or 4 months of an opportunity given to PDS to produce another valid demand guarantee, and same had not been duly taken, the government of Ghana, or ECG, decided to terminate the agreement. So this, with all respect, constitutes the material fact resulting in a termination of the demand guarantee. And I think that it was very proper and right in circumstances.
Very well. Shall I just the date of termination?
Yes,
for the PDS agreement. Just quote it for our purposes. Thank you.
Yes. dated 23rd October 2019. 23rd October 2019.
Oh, sometime.
Right.
Thank you very much, Mr. Chairman. Mr. Chairman, the honorable nominee is accused of leading the effort to disenfranchise voters in the Central Kofi, Akafo, Lolobi areas in the voter roll. What do you say to this?
Everyone, I think it will be very unfortunate for anybody at all, with all respect, to prioritize the role I played in ensuring the preservation of the right to vote.
Let me remind you of Order 93.1 so that you'll be guided in your comments. Reference shall not be made to any matter on which judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of parties to the action. So, once I'm listening keenly, if I have to stop you, I will.
Yes, everyone, I am very mindful of that, and I think that I must place on record that the decision in the Hohoi matter, what we call the SAR matter, is ex-party Attorney General. Was an application filed by the Attorney General to quash a decision of the High Court in a matter that has been filed by 5 residents of Hohoi, led by Professor Margaret Kweku. That decision has been the subject matter of a review application by the respondent, Mr. Professor Margaret Kweku, led by Mr. Chachichikata in the Supreme Court. But just by way of interest, I would say that it will be unfair for any person to say that I led the effort of the people of Hohoi to disenfranchise. If anything at all, it's the opposite, which is the case. I ensure the preservation of the right to vote of the people of Hohoi, because the South area, as far as I'm concerned, clearly has, by dint of CI 128, representation of people's parliamentary constituencies, been placed in the Boom constituency, not Hohoi constituency. So, if the committee looks at page 71 of CI 128, it shows that the South area had been clearly placed under Boom in Oti region, and not Hohoi in the Volta region. So when indeed an application was filed by them and others made to restrain the member of parliament elect for Hohoi at that time from being sworn in, of course, the Attorney General was also a party to the application. The Attorney General was compelled to file an application in the Supreme Court, because to start with, the matter that went to the High Court, who, insofar as it affected the right to be sworn in by the member of parliament of Hohoi, should not have been filed in the Human Rights Court, because it was an election petition. The Attorney General felt concerned, and acting in accordance with my understanding and conviction, I filed this application in the Supreme Court, and the Supreme Court unanimously upheld my submissions and quashed the orders of the High Court rule. But the main point of concern is that the people of Shah are not by law required to vote in Hohoi. They have been placed in Boom in the Oti region. And I remember making a submission in the Supreme Court that if there were any group of people affected, it should be the people of Boom. And therefore, I will lead efforts to ensure that the South people vote in Boom constituency. And if by the grace of God, this honorable court, this honorable house approves of my nomination, I will, in accordance with that submission, ensure that the people of SAM vote where they are supposed to vote, that is in Buem, and not Kohoi.
Thank you, Mr. Chairman. Mr. Chairman, after the Ayawaso West were going by elections, the government constituted inquiry into what happened after the by-elections. Now, the Short Committee issued their report, and the government issued a white paper which rejected most of the recommendations made by the Short Committee. That white paper was signed by the Attorney General. Do you think that rejection by the government, that decision by the government, is in the interest of good governance?
Is that, I would say with all respect that the prerogative of the president to issue a white paper stating a position on the findings of a commission of inquiry is in the best interest of good governance, because that is actually the purport and effect of Article 280 of the Constitution. And Article 280 Clause 3 stipulates as follows: the President shall, subject to Clause 4 of this article, cause to publish the report of the Commission of Inquiry to have the right to power on it within 6 months after the date of the submission of the report by the Commission. Then Clause 5 also, Clause 4 first says, where the report of the Commission of Inquiry is not to be published, the President shall issue a statement to the press, giving reasons why the report is not to be published. Clause 5 says, a finding of the Commission of Inquiry shall not have the effect of a judgment to the High Court, as provided in Clause 2 of this article, unless, and B for me is most relevant, the government issues a statement in the Gazette, in the national media, that it does not intend to issue a finding on the report of the Commission, whichever is the area. So, in this verse, it shows clearly that the President has been mandated by the Constitution to issue a white paper stating a position on the report of the Commission of Inquiry. And the precondition to the findings of the Commission of Inquiry to being considered as a judgment to the High Court is actually predicated on the issuance of a white paper. And for that matter, if the President does not intend to do so, he ought to state it. And if he does not do so, the report does not become judgment to the High Court. Now, I say that the Constitution has cast provisions in this way to show that the work of a Commission of Inquiry is part of the executive functions of government. So a Commission of Inquiry's work is part of the manner in which the executive powers of government are exercised. That's not the Constitution. The fact that the report of a Commission of Inquiry can, subject to certain conditions, become judgment to the High Court does not derogate from the basic fact that the work of a Commission of Inquiry is part of the exercise of the executive powers of government. So it's actually government, it's part of the government work. Now, the government was compelled to issue a white paper assigned by my former boss, Madame Goekufu, and the reasons have been stated there. And the committee will see that the reason why the government was compelled to indicate in a stencil its acceptance or rejection or partial rejection and partial acceptance of the report is on account of the manner in which the work of the Commission of Inquiry itself was done. So, the greatest respect to the membership of the committee, one of them, my former lecturer, Professor Rita Sabutu, and the other, a very eminent jurist, in short, and the other two, very important. The hazard of this honorable house, there is the record of proceedings of parliamentary debates dated 7 July 2011, whereby after the Atiwa incident, the Attorney General was compelled to appear before this honorable house and justify why certain actions in the nature of either Commission of Inquiry or prosecution of the members of persons found to have misconducted themselves in the Atiwa incident were not prosecuted. And indeed, the Attorney General then, Mr. Martin, clearly refused, with all respect, to either institute an inquiry or to prosecute the persons who had been injured and or were the victims of violence in the Atiwa incident. And stated here at page 2360 of the Hansard of 7th July 2011. The column, this honorable house, is an oral answer. The page is 23.
We call it column.
Column 2360. Okay, I stand for it. The people of Wenji will be angry with you this year. So page 2360, column 2360. You find that thing you are justifying why actions should not be taken after the Atiwa violence. And then, for that matter, I think that the president who instituted this Commission of Inquiry and accepted some of the findings ought to really be commended for the bold initiative. But I've explained why it rejected some of the findings. And it was compelled to do so because there is internal inconsistency and contradictions in some of the findings.
Yes.
My second question. Mr. Chairman.
This is your third question.
Oh, the second one was follow up.
How come what Iowa should be a sequel to South?
Mr. Chairman, my next question has to do with legal education in the country. In the past, we only had Legon and Tech to offer LLB degrees. So the existing facility could accommodate them to do the professional law degree. But now we know that JIMPA is offering a LLB degree program. Cape Coast is doing the same, and other universities are actually, offering LLB degrees courses. But we have not done much to expand the facilities at the professional level. Would you consider pushing for those universities to offer the professional courses? Apart from that, what would be your suggestion to reform legal education in Ghana?
I'm very useful, and I recognize that the honorable member is very passionate about legal education. And in my appearance before the committee in 2017, I think the honorable member asked a question on the same line, and he's sticking to his passion. I think I want to be a law student, and I'll be interested in taking on as a people at the appropriate time. That's what I think. Law education, legal education has come a long way. Prior to 2015, the legal education was just professional legal education was just run on the lines of it was structured this way: 2-year course with 12 courses spread over the 2 years. Then in 2015, there was the introduction of entrance examination and interviews. In 2018, pursuant to the professional law course regulations, the interview aspect of it was removed. Well, of course, the examination was reserved. Then there was an attempted restructuring of the course to be on these lines. 1 year law course conducted in the classroom, and another 1 year conducted outside. Conducted outside in the sense that there will be privilege of 6 months in a legal department, firm, or the judicial service. By 2020, the General Legal Council has scrapped that arrangement. But, Mr. Chairman, it is important to say that all these measures were taken in the interest of boosting the quality of practitioners or quality of products that come out of the law school. And I'm also happy to say that there has been a dramatic proposed change in the structure of the law program. So there has been enacted, and not enacted, I'm sorry, there has been drafted a proposed amendment to the Legal Profession Act, because that the change will require an amendment not just to regulations, but this one to the Act itself, Act 32 of 1960. So, as to permit the professional law course from being run by the various faculties which undertake the LLB, that's the Bachelor of Laws program. And I think this represents a very bold initiative, and which will go a long way to expanding access to law school. Over the years, I have always heard the view that the difficulty in having access to law school was occasioned by the disconnect between the manner of regulation of the LLB program and the manner of regulation of the professional law course. Whereas the LLB program was regulated by the accreditation board, National Accreditation Board, the professional law course was run and regulated by the General Legal Council. So you find a situation where there will be in existence many faculties, Cape Coast, Kumasi, and Accra, many of them, and some even Kumasi having companies in Mampong, running LLB programs. And eventually, over 1,000 students will be unleashed onto the scene every year. The General Legal Council will still maintain its grip over the professional law course and have only these 3 campuses, Legon, the old Mapala campus, as well as Kumasi. Of course, there was a limitation in infrastructure. So part of the means to also boosting the fiscal access is to ensure a completion of this law village project, which has been earmarked and it's only supposed to be around Legon or Pesek, for a long time. So, Mr. Chairman, I think that an amendment of the professional, the Law Profession Act, the Legal Profession Act will also lead to a resolution of the long-standing problem of access to law school. And I'm happy to say that there's a draft bill. I believe that if this one will come to the House, by the grace of God, a peace of mind nomination, I will help in ensuring a swift passage of the law, and will also, apart from that, ensure a completion of the law village project. And that will really resolve all the problems, including your giving vent to your desire to be a lawyer.
Yes, Reverend.
Thank you, Mr. Chair, and congratulations, the learned Attorney General and Minister for Justice-designate. What is your legal inclination on the advocacies calling for a capping to be put on the number of judges at the Apex Court?
Grateful for the question. I think that the question itself has implications for the independence of the judiciary. Indeed, the considerations of a cap or limitations on the number of judges that or justices of the Supreme Court that a president may appoint has every relevance for the influence of the judiciary, because there's worry about the president seeking to maintain its grip on the judiciary, appointing justice on the Supreme Court of Ghana. Now, this country has had a convention of maintaining, even though there's no limitation, a number of about 15 justices of the Supreme Court at the time. Mr. Chairman, I think that the issue can be addressed first and foremost through the appointment processes of the Supreme Court Justice Supreme Court of Ghana. The appointment processes are set out in the Constitution. And my view is that if indeed all parties relevant in the process were to perform their task seriously and faithfully, I think that inherent in that will be that check on a president from abusing his or her powers. So Article 144 plus 2 stipulates that the other Supreme Court justices shall be appointed by the president, acting on the advice of the Judicial Council, in consultation with the Council of State, and with the approval of Parliament. So Mr. Chairman, we see four main parties relevant to the appointment process of a justice of the Supreme Court of Ghana. The first is the advice of the Judicial Council. So the Judicial Council itself will have its inbuilt mechanism for ensuring a thorough approval of persons, or a thorough scrutiny of persons who may be advised for appointments. I think that would be the first step. And secondly, there is also required to be consultation with the Council of State. Even if the Council of State is seen to be part of the executive, which some theorists will disagree, and I indeed...
Justices of the Supreme Court, what can the appointing authority do relative to this position? Right. If you marry it, we can enjoy the intellectual discourse on this matter.
So, Dr. One, Article 128 does not place a cap or limitation on the number of Supreme Court justices. It only sets a minimum, and that minimum is 9. So the Chief Justice plus not less than 9 justices in the Supreme Court that constitutes the Supreme Court. The Chairman, there is no upper limit, and the upper limit is determined by the tribunals of the day. The Chairman, that is why I'm saying that I consider the appointment process to be very material. And I'm saying that in order to curb a president who would want to appoint as many justices to the Supreme Court as possible by way of a subtle manipulation of the Supreme Court, the various parties involved in the appointment procedure as set out in Article 144, Clause 2, will be very material. And I'm saying that the first party is the Judicial Council. So the president does not, with all respect, get up and appoint on his own. The president cannot appoint on his own. The president's appointment process, with all respect, will even be considered to be perfunctory, because it is pursuant to activities engaged in by these important elements. And the first institution is the Judicial Council. The Judicial Council does not advise for appointment. The appointment cannot commence at all. So if indeed all these parties relevant here were to take their constitutional duties seriously, with all respect, and ensure that even the case or the situation of a president appointing does not arise, there will be a check or there will be a cure to the problem envisaged by my very good friend, honorable member. That's the point I'm making. And I'm saying that the ultimate work is with this honorable house. Because the appointments, the advice, the consultation, and whatever, you cannot come into effect without the prior approval of Parliament. And therefore, I consider this honorable house, house's role very important. So, even without amending the Constitution to place an upper limit or a cap on the appointment, on the number of Supreme Court justices, there is an internal check set by the Constitution itself for such a restriction to be achieved. Mr. Chairman, I may also add that the problem or maybe the need to appoint many Supreme Court justices has also been very necessary by virtue of the combined jurisdictions of the Supreme Court. The Supreme Court is a constitutional court, is an appellate court, is a review court, is an election petition court, and it's also the court set by Article 135 for giving approval for the release of official documents and what have you. So if indeed there is a right of appeal from every decision of a high court to the Supreme Court, apart from matters which have emanated from the circuit court, clearly the committee will see that there's a need for us to have a lot of Supreme Court justices, because unlike certain countries where the Supreme Court is just a constitutional court, or maybe there's even a constitutional court as distinct from a Supreme Court, in this case, it has combined jurisdictions. So one of the processes that I will also, with all respect, try and seriously pursue by way of law reform is to ensure that the Supreme Court itself exercises its own judicial powers to control the ratification of the plenty cases that come before it. There's nothing wrong with all respect.
Chairman, with your indulgence, the longer you engage us, the more the period will spend with you. What we want from you,
Right.
if you want to take a middle ground, as I understand you, you are saying that the appointing authority, including Parliament,
Yes.
can exercise a persuasion to limit the numbers. Now, your second argument is that given the multiplicity of the role of the Supreme Court, you are for open-ended. Where do you stand? Are you for capping or not?
I think the present arrangement to the Constitution is sound, is proper, and I'm not faulted in any way. And I think that there ought to be rather a strengthening of the rules played by the various.
Are you for capping, limiting numbers to appointment to the Supreme Court as it pertains in the U.S., or you are for open-ended? Just give us an answer for that.
Having regard to the multiplicity of the decisions of the Supreme Court, I am not for capping. I am for a strengthening of the rules of the various institutions.
I am now going to limit you because if I leave you, we're going to spend the whole of the day here. So,
Honorable Chair, you may indulge me to situate my last question in context and with particular regard to Article 35, Clause 5, and with your indulgence, I read, under the directive principles of state policy, the state shall actively promote the integration of the peoples of Ghana and prohibit discrimination and prejudice on the grounds of place of origin, circumstances of birth, ethnic origin, gender or religion, creed or other beliefs. And with due regard for this provision, to refer the Honorable Nominee to Section 104, Subsection 1B of the Ghana Criminal Code of 1960, which states that unnatural carnal knowledge with consent is considered a misdemeanor. In respect of this particular provision, Honorable Learned Attorney General and Minister for Justice-designate, some activists have proceeded that this particular provision I made reference to is anachronistic and therefore not sufficient to fully address the emerging matters of LGBT. And in that position are even advocating for further strengthening of our laws to be able to fully address these matters. What is your view on this matter, and what would be your advocacy for the strengthening of our laws to fully address matters of LGBT?
That's what I take the view that the provision of the Criminal Offences Act does not offend the Constitution at all. I think that, yes, there are cultural rights recognized by the Constitution. My personal view is that it is only when the laws are applied in a way discriminatory of a particular group of people, that you can allege or assert unconstitutionality. I take the view that the decision of the Supreme Court in the James Covenant Bonfe and the Attorney General matter recently regarding the National Cathedral itself is an affirmation of the fact that even though there are multiplicity of religions, the country freedom of religion, and what have you, any decision by a president to promote a particular religion is not discriminatory. In the same way, any practice of a people which seeks to protect its customs and values cannot be deemed to be discriminatory. And for that matter, I would agree that the section of the Criminal Code is not discriminatory at all. I think that what is required is a free society that will not unnecessarily victimize persons, but that is not to be construed to mean that the state cannot put in place certain laws which protect its customs and traditions of the people.
Thank you, Mr. Chairman. That'll be all from my side.
Yes,
Thank you very much, Mr. Chairman. Honorable nominee, I would love to find out whether the data bank was involved in the Ijapa royalties deal. Were they one of the advisors?
Yes, Data Bank jointly appointed with Imara Corporate Company as a transaction advisor.
As a follow-up, given the fact that the then Minister of Finance is strongly associated with Data Bank and is known to be a co-founder and a former director and someone who could be said to have a beneficial interest in Data Bank being appointed as advisors to a transaction like this, don't you think that that may sin against the rules in Article 284? And with the permission of the chair, if I may read, it says that a public officer shall not put himself in a position where his personal interest conflicts or is likely to conflict with the performance of his functions of his office.
I think so. Certain fundamental facts have to be spelled out. Now, Data Bank was founded or co-founded by Mr. Kinufrata, the former finance minister. Now, Data Bank had been engaged in various transactions which are matters of public record involving the government of Ghana. In the 90s, they engaged in a transaction involving Anglo Gold Ashanti and the government of Ghana. In the 2000s, in the President Kufuor era, they engaged in various transactions with the Ministry of Finance as well. In the Mills Mahama administration, they engaged in various transactions with the Ministry of Finance as well, including Eurobond and what have you. And so, the Chairman, the question that necessarily arises is whether the mere appointment of the co-founder of such a company, which has been involved in transactions with the government of Ghana at every material time in the Fourth Republic, is automatically barred from continuing in the performance of its regular functions, just by virtue of the assumption of office of one of the co-founders as Minister of Finance. The Chairman, that may seem to be a little unreasonable, and a perfect completion figure. Mr. Chairman, if that were the case, I'm saying so and I'll address the specific matter stemming of this transaction. Then an Attorney General who also had a law firm before assuming office as an Attorney General, would it also imply that such an Attorney General, the law firm of that Attorney General, would also be prohibited from representing any ministry, department, or agency just by virtue of one of the founders of the law firm being an Attorney General? Of course, I don't find myself in that situation. The law firm I founded as partners, I put it on hold. Before I got appointed, I was just appointed just around the time I founded. So there's nothing like that at all. So I'm not speaking for myself by making this allusion. But it is a notorious fact that every Attorney General had a law firm before becoming Attorney General. In this transaction, my scrutiny of all the documents, particularly the tender processes, the evaluation of the tender processes, does not show any violation of any aspect of the tender processes. And indeed, I do not see any allegation by any person to that effect. The Chairman, the Special Prosecutor, then, it will be very important to quote from certain aspects of the report that he himself prepared, which sought to suggest a conflict of interest situation, a finding of conflict of interest situation. Now, the Special Prosecutor stated at page 3 of the letter that he wrote to the President, the letter dated 16 October 2020 to the President, that the analysis of the risk started from page 2. The analysis of the risk of corruption and anti-corruption assessment in the bid selection process led to the assessment that the involvement of Emara Corporate Finance Limited of South Africa in the management agreement as approved by the PPA made the management agreement a financial business agreement. I've addressed that one already. Then says the slowly, I'm sorry, because I'm reading that. I'm saying it says the mandate agreement does not say made by the auditor, by the Special Prosecutor. And Mr. Chairman, this conclusion, with all respect, seem to be suppositions or inferences that the Special Prosecutor, drew from his assessment, which made the finding that the agreement did not have PPA approval. I've already explained why, in the context of the approval of registered tendering method, the Ministry of Finance had the full authority to determine the rules of the tender and to supervise the implementation of the rules of the tender. So, if indeed just by involvement of data bank, an allegation can be made that there was a reasonable suspicion. Mind you, with all respect, it is not a conclusion that was bid rigging. It doesn't conclude so. It says reasonable suspicion of bid rigging. I think that he actually owed a duty to show how the rules set out in the tender processes launched by data bank, launched by Ministry of Finance, were breached and breached in favor of data bank. And he doesn't, with all respect, show how the tender processes, as I've indicated, were breached by Ministry of Finance in favor of data bank. So that is one problem that I had. But don't you think... Then again, he also indicated towards the end that this assessment does not consider an investigation, even though formal investigations or the suspected commission of corruption and corruption-related offences may arise from this corruption risk. It is not the work of a commission or committee of inquiry. So you find here the same prosecutor, after having made all these wild, with all respect to him, somebody because he's my very good friend. I go to his office and he knows it. He sometimes says that I'm one officer from Ministry of Justice who visits him regularly. when I used to consult him about a lot of things, say that it is not an investigation, it's not the work of a committee or a commission of inquiry, but at the same time, there's reasonable suspicion. I think that he really owed, or the office owes a duty to go beyond this report and after commence an investigation, even and to ascertain whether there was or there was not. Until then, there cannot be an allegation that there was conflict of interest. Now, conflict of interest, again, as is defined in Article 284, is a situation where a public officer places himself in a situation where his personal interest conflicts with the performance of his public functions. The Constitution does not go beyond it to explain or indicate other elements of interest. Thankfully, SHAD has come out with certain guidelines for determining whether there's conflict of interest in a situation. And they allude to one, where there's financial interest of the public officer in the transaction in question. Or two, where financial interest can be imputed to other persons who are associated with the public officer. Or three, where the public officer abuses his public office for private profit. Or four, where the public officer abuses public information, i.e. breach of confidentiality or what have you. Then, SHAD proceeds in the same guidelines to provide two cures for conflict of interest. The first proposed cure is by a disclosure of the interest. And if the committee would note, and it is for this reason why they came up with the findings they did in the ABAJ matter. Secondly, where there has been a removal of the public officer from the transaction in question. The gentleman, as I indicated, because of the lack of clarity with regards to the issue whether indeed by virtue of a public officer having an interest in a company, that company, whenever the public officer assumes office, should be prohibited from engaging transactions. I think I will recommend all reforms in that regard. I think that there ought to be a passage by this Honorable House of the Code of Conduct of Public Officers Bill. The Code of Conduct of Public Officers Bill has been prepared by the Honorable Officer. Until then, I don't see any conflict of interest.
Yeah, thank you, Mr. Chair. Again, when you look at the corruption risk assessment report on page 56, the last paragraph.
Is that corruption what?
Risk assessment report. The same report that he referred to.
Honorable Mathiamidu's
page
risk
56.
assessment report, yes.
On page 56. The last paragraph. This was a conclusion made by the special prosecutor. It says that a deeper analysis of the risk of corruption and anti-corruption assessment of the mandate agreement arising from snowballing by the Deputy Minister led to the discovery that Honorable Charles Edubwahi, the Deputy Minister, who appeared from the analysis of the risk of corruption and anti-corruption assessment to have been the overseeing Deputy Minister for this procurement process for the transaction advisors and purportedly signed the mandate agreement for and on behalf of the Republic of Ghana, knew or ought to have known that he could not commit the Republic to any contract, let alone sign the mandate agreement in the name of the Republic. And he made reference to Section 7 and Section 25.3 and Section 4 and Section 102 of the Public Financial Management Act.
Honorable Member, he has answered and referred to all these things earlier. So may I ask another question, please?
Oh, very well. Very well.
Honorable, so when they were dealing with the capacity question, those were quotes. What probably we didn't know was that it's the same quotes you are referring to the Martin report, but he was on the capacity issue, you referred to that.
Very well, Mr. Chair. Now, my second question borders on your role on the PPA board. Were you a member of the board?
Yes, gentleman, I was. And I think
what was supposed to be your role on that board?
But my role was a member of the board to approve applications in accordance with the provisions of the Public Procurement Act at 663 primarily.
So what would be your response to the concerns that being an institutional rep on that board, you cannot completely extricate yourself from the PPA scandal because you were supposed to be the government's legal advisor on the board?
Right. Okay. Yes, I think even though I've answered, I will go to the importance of the question referring to the ABAD ruling. And I've indicated that the ABAD ruling came up with key findings. None of the findings implicated the board in any way. The findings centered around the personal conduct of Mr. ABAD. And insofar as something in the board was concerned, Shad actually found, for instance, that he even altered the minutes of the board of a particular day. So really those were personal acts, and Shad indicated for the record at page 176 that the key issue was about the respondent, that is ABAD, ABAD's public capacity role as CEO and board member, participating in the decision-making process on applications involving his company. Indeed, the conduct of the board was not an issue before Shad. I've also referred to 7 issues set for information by Shad. None of them bordered on the conduct of any other board member apart from Mr. ABAD. And even Shad also, just for the record, held here at page 158. It says, this investigation abounds with evidence of many instances of the respondent, that is Mr. ABAD, not disclosing or recusing himself during board meetings. And it says, secondly, we also see for documents, but the point has made that clearly the investigation was, or the findings were about Mr. ABAD and not the board. And I will just for the record indicate that the PPA, as was found by Shad, when it engages or approves of a certain method, only approves the method. It doesn't engage in a tender. The PPA does not select companies for a tender. It does not evaluate tenders. It doesn't select companies which win a tender. Those are done purely by the entities. And those entities were not the PPA at all.
Mr. Chairman, my last question borders on human rights. Under your watch as a Deputy Minister for Attorney General and Justice, we've had several human rights violations in the country. The first one, I would make reference quickly to some of our students, even though this may be in reference to legal education, but I consider it as a human rights matter, who were given letter from the Ghana School of Law to Rwanda. They managed to finish their legal education. The president was even in Rwanda. There are evidence showing that, assuring them that he was going to do something about their condition, only for them to finish, come back to Ghana, and as we speak now, they cannot be given a post call. That is one of the major human rights matters I would want you to address when you eventually address this matter. Now, in the 2019 Human Rights Report by the United States Department Bureau of Democracy, Human Rights, and Labor, this was what they found as far as human rights is concerned in Ghana. It says that significant human rights issues included arbitrary and unlawful killings by the government or its agents, harsh and life-threatening prison conditions, violence against journalists, including assaults, death threats, and one journalist shot and killed, censorship of a free press, including arrests, and the closure of 2 radio stations for ostensibly licensing irregularities, corruption in all branches of government, crimes of violence against women and girls, to which government negligence significantly contributed. Infanticide of children with disabilities, criminalization of same-sex sexual conduct, although nearly enforced, and although barely enforced, enforced child labor. What would be your response, your policy response to some of these major human rights matters that were raised in this report, some of which we also know? We know of a number of police killings, some of them are under investigation, but what would be your commitment to the fight for human rights in this country when you're given the nod?
Chairman, I respectfully observe that the matters referred to, or the instances cited by my friend and honorable member, relate to institutional weaknesses as far as I'm concerned. Because the honorable member was talking about violence against journalists, sentencing challenges, child labor laws and all that. I mean, these are things that, with all respect, have been there and have been a result of the weaknesses of the Ghanaian society, and I acknowledge same. I think I can only make a firm commitment to the eradication of same. I myself have been a human rights practitioner for about 80 years already. I have many human rights cases on record, as I'm sure my friend already knows. So I can only, yes, but I will just resist the suggestion that it is as a result of our term or the past 4 years, or all these instances occurring in the past 4 years. I do not think that we can say that, or we can attribute these human rights violations to only the past 4 years. They have always been around, child labor and all. Of course, I see that Ghana's record in child labor has not been impressive at all. And I share your concern. There ought to be very urgent measures put in place to ensure a cessation of these human rights abuses. And I commit myself to it. Of course, the law school issue, as I've indicated, the drafting of a bill that we did. The drafting of the bill occurred, and that represents a very huge or bold step to ensuring expansion of access to the law school. The drafting, the legal profession amendment bill, if passed by this House, will ensure that the faculties are empowered to carry out professional legal education themselves, and there will be a mechanism also struck to ensure proper supervision by a General Legal Counsel. And I've already indicated that we can only achieve a synchrony of access to a law school with access to a professional legal education by ensuring that there is a reform of the regulation procedure. It is incongruous to have law school regulated by the General Legal Counsel and a different arrangement, i.e. vesting in the hands of the National Education Board for the regulation of the LLB program. There ought to be harmony between the two means of regulation of legal education.
Very well. Yes,
Thank you very much. Honorable Nomi, congratulations, Honorable Nomi. I have 3 questions. 1, the Supreme Court recently held in a number of cases that state institutions or entities that the state has some interest in, be it private or public, may use the services of private legal practitioners to prosecute their cases when they so desire. Notwithstanding that, the office is supposed to be the principal legal advisor to government and to represent the state in such matters. Recently, there was a situation where the Auditor General chose to defend a case using private lawyers
And the Office of the Attorney General also think or thought they should have acted for the Auditor General. To what extent do you agree or disagree with the position of the Supreme Court in this regard? Thank you.
Mr. Chairman, I am aware of the decision of the Supreme Court in Amegache against Attorney General, and that was way back in 2012 or 2011. I know that the same decision my learned friend or I member is talking about, the same decision. So I think that's why the Supreme Court did not say that state institutions have the right to engage private lawyers. The Supreme Court rather held that it's only when the interest of the state or interest of government conflicts with that of a particular state institution, and the particular state institution may engage private lawyers. So to start with, public bodies or state institutions are supposed to be represented by the Attorney General. It's the duty of the Attorney General to represent state institutions, and I'm not about, with all respect, to shed away some of my powers. I think that I will still agree that yes, the Attorney General ought to represent all state institutions. That's the comment. It's only when, as I stated, the interest of the government conflicts with that of an institution of state, say the Electoral Commission. That is why the Electoral Commission has the power to appoint its own lawyers. Or SHAD. That is why SHAD also has the power to appoint its own lawyers. But the specific instance of the Auditor General, yes, I myself was the lead counsel for the Attorney General when the Supreme Court indicated that the Attorney General ought to represent the Auditor General. And that was consistent with the position that I had held. Because the Auditor General is part of the public services of government. Auditor General is a member of the Audit Service, and the Constitution says so clearly. The Audit Service Act also says so clearly. There is thus, with all respect, no warrant or basis for the Auditor General to be hiring its or his private lawyers. If the committee looks at Article 189 clause 1 as well as clause 2, it makes this quite clear. So clause 1 says there shall be an audit service board which shall consist of the chairman, and then the Auditor General, head of system. And then clause 2 says the appointment of officers and other employees in the audit service other than the Auditor General shall be made by the audit service board. So inherent in this provision is a recognition that the Auditor General is part of the audit service. The provision only says that the appointment of other members of the audit service, apart from the Auditor General, shall be made by the audit service board. But to make this position quite clear, the Audit Service Act has stated in section 2, the membership of the audit service. In 2 of the Audit Service Act says members of the service. The members of the service are A, the Auditor General, and B, other persons employed in the service. So, quite clearly, the Auditor General is part of the service and therefore part of the public service of Ghana. Because Article 195 has stated the public services, Article 190, has defined the public services of Ghana to include the audit service. So clearly, you see that the Auditor General is supposed to represented by the Attorney General. And that is what the Supreme Court held in, I think, the first day of the hearing of the Professor Asari matter. The matter that Professor Asari had filed challenging the powers of the President to appoint, to ask the Auditor General to proceed on it. On the first day, the Supreme Court held that I ought to represent the Auditor General. So I think it's quite clear. Also, perhaps the Attorney General has to boost his or her capacity to employ more lawyers so that he can effectively represent all members of the public service. That's all.
Thank you. My second question, please, can we look at Article 58 and 295, as well as provisions under Article 88 on the office of the Attorney General, which is a creation of the Constitution. See? In 88.1, a dual role is created for you as a Minister of State and the principal legal advisor to the government. And government is also defined in Article 295, I'm sure. You will be Minister of State, God willing. The President is the head of government, and government is defined to mean the executive, I'm sure. The President may have his political interest. You are an appointee of the President. You are going to be the principal legal advisor to the government. To what extent would your obligations to the President and the Constitution come to play should you be required to give a fair opinion on matters affecting the state to the government in that dual position? Thank you.
Mr. Chairman, I think that yes, I recognize the points made by my left friend, the honorable member of the House. Mr. Chairman, again, I would say that an Attorney General ought to act in accordance with the details of the Legal Profession Act, the Legal Profession, professional rules and of conduct and etiquette rules. And indeed, an Attorney General is supposed to act faithfully to the state. Attorney General is supposed to be the vanguard of the rule of law. It's supposed to be the protector, the first protector of the citizen as well as of the courts of Ghana. And I would say that in my track record, with all humility, will show that I act faithfully and impartially, regardless of political affiliation. And I can cite the case involving an honorable member of this House, Mr. Kennedy Japan, and when he found himself in a situation which bordered on contempt of court, and the Attorney General was ordered by the Supreme Court to defend the judicial service because a justice of the High Court had exercised his powers to cite Mr. Kennedy Japan for contempt. I was called upon to defend the Justice of the High Court against Mr. Kennedy Japan, who we know is a leading member of the MPP. The record will show that I actually mounted a defense of the judges of this citing Mr. Kennedy Japan for contempt. I was not persuaded by the fact that Mr. Kennedy Japan is a leading member of the MPP and also a leading Santa Clausian for that record, for the record. I was not persuaded at all. I defended him and the judge of the High Court against Mr. Kennedy Japan. And I think that is recorded in the judgment of Justice Yoni Glendy, dated
No, is it Yoni Glendy, the Justice of the Supreme Court?
Yes, please. This is Justice Glendy, Justice of the Supreme Court. In the case of the High Court, Land Division, Accra, Eswatini, Japan. So when I was called upon to indicate whether the conduct of a leading member of the MPP bordered on contempt, I agree that indeed his conduct bordered on contempt. And so the record we show, page 14 of the judgment, said it was argued for and on behalf of the respondent by the learned Deputy Attorney General on 14th October 2020 during his oral submissions before us that the application was fundamentally misconceived. And that is Kennedy Japan's application was fundamentally misconceived. The same was predicated on the false assumption that there are different high courts. Then he goes on. The decision of the High Court vested in the Justice of the High Court includes the power to commit for contempt, as clearly enshrined in Article 126 of the Constitution. There is therefore no doubt that His Lordship, Justice Amos Wuta Uli, had the power to commit for contempt, even though the words in question were allegedly spoken of a different Justice of the High Court. He cited the edition of the Kufadi CJ in the case of the Public University Press to back his point. Mr. Chairman, before you is a judgment in which I have against the interest of a member, leading member of the MPP, defending the administration of justice and all. So I can give that assurance to the court, to the committee, that when appointed, I will faithfully administer justice, irrespective of political affiliation or ethnic origin.
Yes.
Honorable Minister-designate, we all respect you at the bar. To that extent, I've seen the bar president in the chamber to observe proceedings. You are going to be the leader of the bar.
Honorable Member for the Central, you know that it is unparliamentary to refer to people in the gallery. So please cut it out.
Very well. I just saw him in the corner, far corner, Mr. Chairman. And you are going to be the leader of the bar. There's been some issues between the bar and the bench, which has led to some lawyers being called before the General Legal Council and what have you. What are some of the things you have in mind to bridge that bar-bench relationship when giving the nod? Thank you.
Did I tribal manipulation? Is it tribal manipulation? What would I do? I didn't get the tail end of the question.
That you are going to be the leader of the bar. There's some issues between the bench and the bar that lawyers do complain about. As leader of the bar, what are some of the things you are going to introduce to bridge that conflict somehow between the bench and the bar to foster some sanity within the profession? Thank you.
That's why, are you talking about the situation where Justice courts complain about the conduct of certain lawyers which border on contempt? Right, that's all. That's what I will review that lawyers ought to abide by the rules of their profession. I am, with all respect, very conservative in my thinking, even though relatively young. And I would want to adhere to the time-honored virtues of the profession. I am also of the view that, yes, judges also ought to act in accordance with the code of their profession, which is to treat lawyers with dignity and respect and to conduct their proceedings fairly and write very sound judgment which can stand the test of time. So I think that, with all respect, harmony can be achieved between the bar and the bench by an adherence by both sides to the dictates of their code. So if a lawyer is to observe the fourfold duty of a lawyer, first, duty to the client, a duty to the court, duty to the profession, a duty to the public, and by ensuring that when cases are pending before courts, they do not make unnecessary comments which will prejudice the outcome and which will actually even undermine the foundations of society. I think harmony can be preserved. Secondly, if judges are also exercise their discretion fairly and soundly in accordance with the dictates of justice and the rule of law, the nation will also be better off and will have a sound question. I don't know if I've answered the value frame.
Thank you very much.
Well, yes, Honorable Samuel.
Most grateful, Mr. Chairman. Mr. Chairman, I would have a few preliminary observations on the CV very quickly. It shouldn't take us more than a minute. I have tried to reconcile this year's CV with what was presented to us 4 years ago, and I hold in my hands the Hansard of 6 April 2017. I noticed a few matters for our records, accuracy and consistency, and educational background. In 2017, you had an entry for a short course at Oxford, June to October 2006, but that doesn't find expression in the current CV under your educational background. Is there a particular reason for that?
Well, indeed, it does find expression. It finds expression under academic fellowships and awards. I recognize that was a fellowship by the Open Society Initiative and resulted in the pursuit of the program in comparative law, media law and policy at the Center for Social Legal Studies in Oxford in 2006. I felt that because of the specific provision for fellowship, I should bring it under that part. So that's what it is.
Thank you very much. At page 5 of your CV, the second entry, your Project MV versus Attorney General, constitutional challenge to the Military Defense Cooperation Agreement. Should that be the Ghana-US Defense Cooperation Agreement? You do not specify, just for our records. Which defense cooperation agreement would that be?
Yes, that's the Ghana-US Defense Agreement.
I also observed that under leadership positions held, you don't give us a specific start date. You may want to consider that later for our records. And then at page 6, the third entry, do we have your permission to clean that up? The chairman, Greater Accra Regional Football Association, disciplinary committee appears repeated.
That's right, yes, this is my committee.
I don't know if you noticed that.
Yes.
April 2008 to February 2009. Chairman, Greater Accra Regional Football Association. Disciplinary committee.
Yes, that's why I think the last one should not have been there. It was a repetition. This is my committee.
Thank you very much. I want to begin with my substantive questions. A matter I have been probing since this hearings began. Should I say famous or infamous airport testing antigen test by Frontier Healthcare Services? So far, my expedition has been quite cautious and eventful. The health minister tells me he has no idea. He has incited the agreement. The foreign minister-designate told us yesterday she was not consulted. You were in the Attorney General's Department, so 88.1 makes you the principal legal advisor to government. Are you aware of this transaction? Did you prefer any legal advice to this transaction?
That's the one. I was not the principal legal advisor to the government. I was Deputy Attorney General. And my Lord, the duties of the Deputy Attorney General or Deputy Minister is to assist the Minister on matters that are assigned. That's why I'm not in a position to tell whether indeed it was referred to the Office of Attorney General. Even this afternoon, I've indicated that the department transaction, we would have spoken about it extensively. I was not the one who went on it. I was not, because the Attorney General assigns work as and how is necessary.
A follow-up on that, it appears my cautious expedition continues. Fortunately, you were wearing two hats. So if I can't get you with legal principal advice, you served on the governing body of the Public Procurement Authority. Did that transaction come to the board's attention?
Mr. Chairman, readily, off the top of my head, there are hundreds of approvals that are taken by the PPA every week, hundreds of them. So I cannot tell whether this particular one, and most of the time, because I'm Deputy Attorney General, coupled with court, when they are sitting around 10 a.m., I will be in court. I will not be there.
Mr. Chairman, I will move to my second question, which will be grounded under Article 296 of the Constitution, which, Mr. Chairman, I read. Where in this Constitution or in any other law, discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. You assisted the respected Attorney General, the Honorable Gloria Akufu. There are two discretionary matters I want to present to you today to explain to us why you exercise that discretion in that manner. The first one is the Aisha 1 matter, which you filed a nolle prosequi and decided not to pursue that matter. At the time, the President had declared war on Galamsey, which continues to wreak havoc and is really an existential threat. We will not have water in the next few years. Already Ghana Water Company is saying they are processing below 40% because of Galamsey. At the time that Ghana was giving Aisha Kwan a free passage back to China with roses, the Ivory Queen in Tanzania was jailed 15 years. Your counterparts in the Attorney General's Department in Tanzania jailed the so-called Ivory Queen, as she was known. Yang Feng Lang is her name, for 15 years for exporting elephant tusks in Ghana, despite the President's war on Galamsey. You exercise that discretion to give Aisha 1 a free and safe passage. The second matter of discretion I take issue with is one of our colleagues, a former colleague of this House, senior colleague of this House for that matter, the Honorable Inus Hussein, who in the exercise of his free speech after the election said that in his personal view, if he was President Mahama, he would have declared himself winner and announced a government. As we speak, you are prosecuting Inus Hussein under Section 207 of the Criminal and Other Offences Act 1960. You have charged him for what you say is, or what the law says, is a breach of an offensive conduct conducive to breaches of peace, if I'm to be specific. At that same time, another member of this House, the Honorable Kennedy Japan, publicly stated, which was widely reported, and actually threatened to burn down the house of our flag bearer, the former President, His Excellency John Dramani Mahama, and the house of Bevlolate, Asiedu Nketia, and other NDC bigwigs. Unlike Inus Hussein, he is not being invited, he is not being prosecuted. Are you not exercising your discretion in a whimsical, capricious, and arbitrary manner, contrary to Article 296B of the Constitution of Ghana, on these two matters?
That's why I'll be very grateful to know the date on which the prosecution of Mr. Inus Hussein commenced.
Inus Hussein tells me his next court appearance is the 22nd of February.
No, when the prosecution was commenced.
I will have to check that.
I was inquiring about this because my term as Deputy Attorney General lapsed on 6 January 2021. and after 2021, I ceased with Deputy Attorney General. To date, I have no lawful mandate in the office, and therefore I could not have been involved in the prosecution of Mr. Hussein. My former boss, Madam Godfred, also the same. Her term lapsed on that day. Perhaps the prosecution is being done by the police. I wouldn't know. Now, regarding ISAP 1, the chairman, that was a discretion exercise by the Attorney General. Attorney General has powers under the...
I'm sorry, Mr. Chairman, if you permit me. Before you move to ISAP 1, what is your view on these two matters moving forward, if given the nod?
That one, I will... of a knowledge possified. I will know that a knowledge possified is entered pursuant to the Criminal Procedure Act, as well as the constitutional powers of the Attorney General to control the conduct of criminal prosecution in the country. The chairman, the Supreme Court has held in Gregory Afuku versus Attorney General that the powers of the Attorney General to enter knowledge possified is not questionable, cannot be proved by anybody, including the courts of Ghana. And for that matter,
within the courts of Ghana, what about here, Parliament? If we are interested, we will ask you, why did you exercise that power?
No, yes, that's wrong, but I was not the Attorney General. That's the point I was coming to. I was not the Attorney General. So only with all respect, my former boss, Madam Godfred, would know, and indeed she is not bound, as I said, even to disclose it to the court. And so that the reason for the entry of knowledge prescribed has not been published. And I will know why.
I want to come to the third matter of interest to me, which is fighting corruption. Corruption is a canker, very destructive, very corrosive. It destroys every facet of society. You have spoken extensively to exonerate yourself on the ABA, AJPP sources that will give board members to protect the public purse. The lowly Manasseh Azuri Awuni discovered this gross act of corruption. Are you telling us that as a board, you had absolutely no role in preventing this heist which took place?
Dr. Chairman, I am not seeking to exonerate myself from anything at all, because my conduct has never been the subject matter of any query, scrutiny, or investigation by anybody. And as I've indicated, the record available to me, which I can make available to the committee as well, the ruling of the Commission on Rights and Administrative Justice in the ABAJ matter, will show that it was a personal conduct of Mr. ABAJ, which was the site matter of investigations. And such came to findings, the key findings, none of them borders on or impugns the conduct of the board, or including myself. Mr. Chairman, I will have to clarify that, yes, the role of the board under sections 38 and 40 of the PPA Act is to approve of applications for research tendering and single sourcing. Mr. Chairman, that approval, especially for research tendering, as I've indicated, is an approval for the entity to go and commence a process of tender. The only reason why the entities have to come to PPA for approval is that it is restricted tendering. By restricted tendering, it is limited to entities selected by the procurement entities themselves. And so the PPA will determine whether there are grounds for the entities to engage in restricted tendering. When such approval is given, the entities, as I've indicated, pursuant to section 39, will commence a process of restricted tendering. Competitive tender, apart from a particular section, because it's not competitive, will apply. That is why I said section 39 is very important. Now, Mr. Chairman, perhaps I only will even indicate to you that the very first time I got to was when he himself called me on phone after the investigation. and stated that it's because of, with all respect and all humility, how the little respect that he had for me. And he knew that I knew nothing about it, and indeed, that issue even came to his own attention in the course of an interview he had elicited of Mr. Ibeji, which was unrelated to the matters that he had notified Mr. Ibeji about. And then the gentleman himself, Mr. Ibeji, volunteered such information. That's how he got to know. And that's when he got to know, and he came up with this. In fact, I think the Saturday before he came up with this report was when he called me to inform me that, he thought out of respect to me, because he respected me so much, and I've assisted him on numerous occasions by giving information freely, matter of public record. He felt it right to inform me.
So, Mr. Dame, you don't think that Section 4 of Act 914, which says the board shall ensure the proper and effective performance of the functions of the authority, together with Section 3D, functions of the board, monitor and supervise public procurement and ensure compliance with statutory requirements. You don't think the board check its responsibilities pursuant to these provisions of the Act?
So, the second one, yes, monitoring of public procurement includes ensuring whether entities who have been given approval by the PPA have complied with what the law requires them to do. We're talking about a situation where, as that itself noted, Mr. ABJ did not disclose his interest in certain companies, and that clearly was out of interest. We're also talking about a situation where, as Charles noted, according to Charles, certain minutes of the board were altered by Mr. ABJ. Such a circumstance, how can it amount to a violation of the rule of the board in Section 4, monitoring transaction? It's also important to indicate that the conduct, this report, the site matter of a challenge by Mr. ABJ in the court of Ghana, and therefore we must, with all respect, have regard to say,
well, I believe as public officers we can hold ourselves to much higher standards than that. Finally, from me, under corruption is the Ameri matter. The president submitted to this house an executive approval under his hand.
Yes.
We were later told in a Daily Statesman report that the president was misled. Could it be that it was the principal legal advisors, the Attorney General's department that misled the president?
I am not aware of such a situation, the Attorney General misleading the president anywhere at all. I'm rather aware of an opinion of the Attorney General indicating that there were no grounds for termination of the agreement, and subsequently I'm also aware of a revision, if I may say, of the agreement by the Minister of Energy, whereby savings in the sum of about $57 million was made. Those are the facts that are available to me, and that resulted in the innovation agreement.
Honorable Ablekuma, Central, or no, West, or I was confused with Central.
Mr. Chairman, you keep assigning other constituencies to me, except Ablekuma West.
My apologies.
The good people will be very happy with us. Mr. Nominee, congratulations on your nomination. If confirmed, you'll be the youngest Attorney General in our history and the leader of the bar. Do you think that, excuse me? I said he would be the youngest Attorney General in the history of this country. Do you think that that would be an inhibition on your performance in view of the fact that you would have several seniors that you would have to superintend over? And how are you going to manage in view of this perceived challenge to, or would-be challenge to your authority?
I'm very grateful for the question. I may be young, but I think the records also show that in 1966, when Mr. Victor Wish was appointed as Attorney General, he was about 43 or 44 years. And Mr. Jogati, when he was appointed Attorney General, was about 45 years. Then, Mr. Chairman, again, Kwame Nkrumah's Attorney General, Mr. Paul Swansea, was also 41 years, but this, I think I beat him just a few months. No respect. Mr. Chairman, even the immediate past Attorney General of the United States of America, Mr. William Barr, I think the records show that this was his second term as Attorney General. The very first time he became Attorney General was in George H.W. Bush Sr.'s era, and 1991. I think he was about 39 years only when he was appointed as Attorney General of the United States of America. The Chairman, apart from that, yes, as Deputy Attorney General, I had the experience of also working with the same seniors at the bar, at the Attorney General's office, and I think that on many occasions I actually, in all humility, supervise their work, and I did so efficiently. I think having served as Deputy Attorney General for 4 years, I've had patient enough opportunity to learn, and of course, I only have acted in accordance with the dictates of professionalism, and I'm sure with God be my guide, and the help of this novel called House as Usual, House as Usual.
Thank you, Mr. Chairman. We're living in interesting times currently with the election petition currently ongoing. We've seen that during the period of the 2013 election petition as well, the Supreme Court came down pretty heavily on people who commented in their opinion wrongly about some of the matters appearing before the court at the time, and exercised their right to punish for contempt. We've heard some pretty interesting comments being made currently about the proceedings in the court. In your view, should the Supreme Court exercise its power to commit for contempt in this current situation? Or what do you think about this general exercise of this power of the court?
Thank you, Mr. Chairman. I think that on this issue, I'll be guided by the words of Akufo-Addo CJ in the Republic versus Liberty Press, that justice is a closet virtue, but of course, judges, they don't live in cloisters. The point is that administration of justice is very essential to the functioning of society, and therefore, the courts play a crucial role. It is of absolute necessity that the sanctity and integrity of the judicial process ought to be preserved at all times by all role players, especially lawyers. And I think that lawyers, if we destroy our profession, there will be nothing for us to go back to. And for that matter, it's important that lawyers become the very first defenders or very first people who ensure that the streams of justice flow unimpeded without unnecessary comments and interference by way of comments that they make. And so, again, it is also important that the judiciary, even though they are vested with the powers of contempt, also have the guard for the fact that the judgments and orders that they make will become the subject matter of interest and discussion in the media and the public space. And for that matter, the exercise of powers of contempt ought to be made only sparingly. So I think there ought to be a fine balance. As I always say, yes, we all must have respect for our respective roles. And so if the public, especially lawyers, recognize that when the streams of justice are flowing, they ought to flow without any unnecessary interference in them, there will be few instances of applications for contempt or the court exercising its powers to cite them for contempt. And the judiciary also, yes, it must also be only in cases of seriousness, whereby comments clearly have interfered with the affairs of justice, that they cite the powers of contempt. And it is, I think I should also deplore the attitude of certain lawyers when cases are going on, they go and make certain judgmental comments about the matters, and also seek to delegate the integrity of the court. I think that's very bad. And I will not hesitate at all to exercise my powers with all respect, as I think you are confirmed. First, to sign for contempt. And the record will show that I will not do so at all. And I will do so in appropriate cases.
My final question would be that having been in the Office of the Attorney General for the past 4 years, I'm sure you're very well aware of the challenges that state attorneys encounter in the course of their duties. And I'm not sure if the staffing situation has improved, but a perennial issue was the numbers of state attorneys available to do the volumes of work that ended up on your table, and the conditions under which they had to work. Has it changed since you got there? Have you worked has something been done to improve the conditions of service of the state attorneys? And what would you do to attract more young lawyers to take up professions in the public service and help improve the human resource capacity of the service and thereby enhance your own efficiency and effectiveness?
Mr. Chairman, I am happy to say that indeed the conditions have improved, but of course not satisfactorily. Conditions have improved because the past 4 years, under the leadership of Madam Godfred, 110 state attorneys were employed. And that represented a very huge addition to the number of state attorneys. 2018, 60 were employed, and then 2018, 60 were employed. In 2020, another 50 were also employed, making 110. The current staff strength is 226. 226 is just about the number of an average law firm in the United Kingdom. In the United States, you have thousands of lawyers. And I think if the Attorney General is to exercise constitutional functions of being the principal legal advisor to government, which includes ministries, departments, and agencies, there ought to be even a quadrupling of number. So, if by the grace of God I'm appointed as Attorney General, I will work effectively with the Minister for Finance to ensure that there is a release of funds for the recruitment of maybe even 500 more lawyers, so that we can measure up to the demands of Article 88. Secondly, in terms of facilities, yes, there was the acquisition of 36 vehicles over the past 4 years, and that was also a significant boost. But the 36 vehicles, with all respect, still not enough. We find a situation where state attorneys have to travel to Isawam to negotiate, to deal with the concerns of inmates at the prison, and also to undertake this Justice for All programs, not having vehicles at all. Physical space is a major problem. There is even a lack of sufficient desk, common desk for the attorneys to work on. It's even a problem. Meanwhile, during the term of His Excellency the President as Attorney General, there was a commencement of a law house project. I think Madam Honorable Member, Madam Cook was in the office at that time. So the law house was commenced after the President left with successive Attorney General. The law house is uncompleted. There is an urgent and pressing need to ensure a completion of the law house. I think when the law house is completed, it will go a long way to providing better office space for the lawyers and the Attorney General's office in Accra. around the country, there is a need to set up offices. Offices have been set up already. There is a need to provide office accommodation for all the lawyers in the 60 regions of Ghana. Very good.
Yes, let's look at it.
Thank you very much, Mr. Chairman. Honorable nominee. Mr. Chairman, before I ask my questions, I think my question on the JAPA has been answered, except to put on record for academic health that the powers of the special prosecutor in looking at the JAPA transaction was pursuant to Section 2C, 4, 29, 69, 73 of the Office of Special Prosecutor Act 2017, Act 595, and Regulation 31 of LI 2374. That's it. Then I move to my question, which is a follow-up to that of Honorable Ahi. He was worried that the white paper of a short commission rejected some of the recommendations of the commission. I am interested in the one that government admitted to do. So if you look at page 23 on compensation, the government agreed to compensate the persons mentioned in page 59, paragraph 9.1, and they are Theophilus Sedofu, Seidu James Mohammed Kisharu. The President asked that the Attorney General, because there was no assessment of their injuries, the Attorney General look at it and make sure that compensations are paid to them. Can you tell me the status of this? Thank you.
Chairman, I think the difficulty I find myself in is that I was Deputy Attorney General, I'm not the Attorney General. But of course, I will indicate that, yes, the challenge that perhaps the Attorney General faced was a clear indication of the extent of injury and the quantum payable. So it rendered it then incapable of determination, but of course the Attorney General had to assess. I don't think that assessment has been done. I think that, yes, we can perhaps look at the provisions of the Civil Liability Act. It's an old Act 1963, Civil Liability Act 1963, which provides mechanisms for determination of compensation payable in case of injury, fatal injuries, and what have you. So I can make a commitment to this House that if granted, if approved by the House, I will ensure an implementation of this recommendation. Otherwise, the state will find itself in what is anticipated by Article 293, the claim against the government. That where a claim is against the government, then the government will be perceived to be like an ordinary person, and that person can go to court. We do not want that at all. Thank you.
Okay, so a follow-up on that one. There was also needless shooting in the Chima itself on 8th of January, which caused the death of some young people. Would you also like to advise for a commission of inquiry to be set to investigate properly what led to the shooting, with the assurance that these needless shooting will not happen again? I'm sure that will go a long way in promoting the security health of the people in Techiman.
Mr. Chairman, clearly, 8th January, I was not in government. I will have to first be in government before I examine the circumstances of the matter being adhered to by the honorable member. And of course, we will see whether it will not be, as I said, the Attorney General came to this House in 2011, July, after the Achua a tour incident, or perhaps the president will be advised on that, on the formation of a commission of inquiry. Mr. Chairman, I will have to first find myself in the office before I can effectively take any action on the issue.
When we were vetted 4 years ago, the question of legal education came up. We are all minded of the kind of lawyers we churn out. We are all looking for quality. You indicated that there is a law village that was being proposed and that you are going to assist your minister to ensure that some monies are released for the construction of that law village to enhance legal education. Can you tell us the status of that project?
Chairman, yes, the law village has been earmarked to be constructed for about 15 years now. It's been there. Unfortunately, I was not a member of the Regional Legal Council during the 4 years. But I remember members of the Regional Legal Council told, I think the Chief Justice himself told this honorable court about even a planned, this honorable house, I'm sorry, the Chief Justice during his appearance before the committee told this honorable house of a planned expansion of the law school by the allocation of a facility around the IPS, Saturdays, now it's University of Professional Studies, I'm sorry, around that university to accommodate about 1,000 students even last year. Unfortunately, we all know the results that emanated from the examination. So, but the law village, as far as I know, is still on the drawing board, has not been done, and I will ensure that it is done. I think it must be done in order to provide additional space for the law school.
Okay, then finally, but take note, Honorable Nominee, that this is the second time you are talking about the law village, and we want you to really pursue it.
That's my hope. The reason why I couldn't do so, I was not the member of the Grand Legal Council.
Okay, so the last one.
How many last ones do you want to have?
No, I've asked 2 and a follow-up, so this is my last final.
You said my last one.
Okay, so my last one is on legal aid. How do you, if you are giving the nod, how do you hope to improve legal aid service in Ghana? I give Techiman Bono East as an example. There is only one legal aid officer for the whole region, and I'm sure throughout the country, you know that we don't have a lot of legal aid officers. How do you hope to improve legal aid?
Powers and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at the kosher rubbish dump collapsed.
It's going to be fun to see how he goes about approaching this game.
powers and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at the kosher rubbish dump collapsed.
It's going to be fun to see how he goes about approaching this game.
that they deserve a full ministry to attend to them, wanting the creation of a Ministry of Parliamentary Affairs. Can you convince the public?
Mr. Chairman, thank you very much. Yes, it's absolutely important to have a Ministry of Parliamentary Affairs. And it is so because, first of all, let me clarify the situation. The clerk is the head of the Parliamentary Service. That is the administrative wing of Parliament as an institution. Now, in every Parliament, there are two legs: the chamber activities and the group that services the activities conducted in the chamber. Now, in the chamber, we have members of Parliament, and every Parliament will have, political divide comprising the caucus, the majority caucus, the minority caucus. In some jurisdictions, you have a place for recognized opposition groups. Unfortunately, we don't have it. In some jurisdictions, if a party attains a certain defined number, like say 5 or 7 or 9, that party will be recognized itself as a recognized opposition group. As I said, we don't have that. We just have majority, minority. Now, the minority is headed by the minority leader, and the majority caucus, which for now elect to call it the majority group, is headed by the majority leader. Now, the two together, if you have the majority-minority, to the extent that we may want one person to speak for the House, the majority leader will be the leader of the House. And then you have the clerk. When you have the two coming together, the Speaker is the head. And that is why the Speaker is the head of Parliament as an arm of government. Now, moving beyond that, you ask whether you're required to have, beyond this configuration, whether you're required to have a minister to be in charge of parliamentary affairs. And I responded that indeed we need one. One, because, as you do know, the activities that are conducted in Parliament, especially in our part of the world, about 90% of public business is government business. Now you're required to have the leader of government business to have an understanding of government business in order for him to be able, for him or her, to be able to convince and persuade his colleagues that this is a good program, this is a good policy that must be supported by Parliament. And so it's the reason why you need a minister who will be a minister for parliamentary affairs, to be in cabinet where policy evolves, to be able to understand himself and appreciate the underpinnings of any policy or program, so that when he comes to Parliament where he would lead the business, he would then be able to understand and have a buy-in from his colleagues and compatriots. So that is how come in many establishments you have this. The parliamentary system, the Westminster system, where members come from, all ministers come from Parliament, is where often you have disagreements. I recognize that ours is a hybrid, and it's the reason why we have imported this into our system. We have this in the first and second parliaments of the Fourth Republic, and continued by President Kufuor. President Rawlings had it, and the Honorable G.H. Owusu Echampo was the first minister, succeeded by Dr. Kwabeneji. President Kufuor continued it, but it was prescribed under President Mills and President Mahama, has been resurrected by President Kufuor. So that is the trajectory of the ministry in the Fourth Republic.
You don't think that, even though the Constitution prescribes a hybrid system that makes ministers, at least 50% of ministers to come from Parliament, that push the boundaries and promote some level of the independence of Parliament, that we don't encourage the leader of the Parliament to be an appointee of the president. If we can push a little to ensure some independence of parliament, that the leader, you can have your ministers come and be part of the house, but the leader of parliament shouldn't be the appointee of the president.
First of all, it's not entirely true the position that you state, that the leader of parliament or the leader of the house would be the minister. If you have a position, a situation where, like 2013, when the MPP took the matter of the elections to court, right? If the MPP had won the case, President Akufo-Addo was going to be the president. At the time, the MPP had just 150 members in parliament. The leader of government business was going to be the Minister for Parliamentary Affairs. So it is not always the case that the majority leader will be the Minister for Parliamentary Affairs. It's not always the case. You get it wrong because of the importation of, that is, lock, stock, and barrel of the Westminster system into our standing orders. So you see that discrepancy in the definition of majority leader and minority leader. That's where the conflict is, because it's an importation of the Westminster system into the definition, which is wrong. So you must have that clarity before you proceed further. So I know where you're going, and it's very slippery for you yourself. So let me offer that clarity. And second, the issue also is the ministry is supposed to provide an interface between Parliament and the executive, and also the other constitutional creatures, right? So that if any policy program is coming on board, it's supposed to be the funnel to sieve whatever is coming from these constitutional bodies, what the impact on them would be. You want to listen to NGOs, to civil society organizations as well, right? And then you fit it into that loop and bounce it off to government again. And then it also provides platform to sensitize the general public about government programs and policies. Because often when matters come to Parliament, they are seen to be being rushed through Parliament. If these are known, the agenda of government is known to the ministry, to the leader of government business, these things could be in the public domain long before they are even introduced in Parliament, so that public sensitivities and public opinion would feed into government programs and policies even before they are introduced in Parliament. And that makes it richer. So, again, it's a justification for the creation, indeed, resistance of the ministry. It's no duplication, and there's no conflict at all. That is if we have clarity of role definition. I do remember that when we had this peer review, when they came to Ghana, they thought that the ministry existed just to emasculate Parliament. Because in those jurisdictions, there are presidential systems, strict compartmentalization, and ministers are not chosen from Parliament. So they didn't understand. That's the reason why it fed into that report. But it was no perception.
You are proposing standing orders, new standing orders. New standing orders are being proposed. And in those new standing orders, we as the House are considering allowing heads of constitutional bodies to appear before Parliament to answer parliamentary questions. It's in our proposal for new parliamentary orders, constitutional bodies, heads of constitutional bodies. In the Constitution, those who can appear or attend Parliament are clearly spelled out. The President to deliver special messages, the Vice President to attend but without voting rights, Ministers who are not members of parliament are clearly spelled out as capable of attending without voting rights, and deputy ministers, and then elected members of parliament. These are the constitutionally allowed persons to attend parliament. The new proposals that you are making is seeking to directly hold heads of constitutional bodies accountable to parliament by saying they can be summoned to come and answer questions like any other minister. Do you think that is consistent with the spirit and letter of the Constitution?
Thank you very much. First of all, I'm here as Minister-designate for Parliamentary Affairs, Ministry. The question that you are asking me relates to my capacity as Majority Leader. But to answer directly, I don't see any constitutional prohibitions as far as those bodies are concerned. We must recognize that the Constitution empowers us with the authority of oversight of all these creatures. How are they to come before us? Are we going to limit them to just appearance at committees, which include committee of the whole, or that we should allow them, we should create space for them to be able to respond directly to us? I do know that the case that is before the courts now, the election petition, an aspect has been raised about the constitutional responsibility of the Electoral Commission in respect of transparency and accountability. How are they to account to the nation? Through Parliament. And that is why it's not Osechi Mensah Bonsu, but the leadership of the House considers it worthy to create space for the constitutional creatures to live up to their responsibility, and also to empower us to seriously interrogate into their administration and activities. A thought that will really reposition Parliament and strengthen Parliament in the performance of our oversight responsibilities.
You want to ask your leader a question? Okay. Okay.
I'll stop them. Respectfully, Leader, the current construct of our laws shows the primary duty of MPs as members of Parliament to make laws. How do we reconcile this with the overwhelming public opinion that MPs must also become development agents in their constituencies? And we know that the MP is elected, the assemblyman is elected, but these people don't have access to development funds. Please, with emphasis on the MPs, do you agree? And will you take steps to ensure that our laws are amended to give MPs some funds to serve as development agents in our constituencies?
Mr. Chairman, when I was listening to my colleague, I thought it was a Sam George voice. Yes, I was looking for Sam George, and the voice is Mr. Chairman, I think it's a very important issue that my colleague raises about the perception outside in the public domain that members of Parliament are development agents. Let me say that it's not only the members of the general public who so think, but our own conduct, we also feed into that. Mr. Chairman, I was telling colleagues over the previous weekend that if anybody should move, flying the road from Kumasi to Tamale, the billboards that heralded the conduct of parliamentary elections. Many of them are still in place. Look at what we have written on them. You said for Mpuntu, vote for John Kuma. So the general public wrong to believe in the fact that you are saying that you are responsible for development. Right? We feed into that. Wrongly or rightly. But you see, again, in the elections, high-profile elections, it is the face of the member of parliament which is out there in the constituency, his or hers and that of the president. So the MMDCs who are responsible for the government at the local level, they are not voted for by universal adult suffrage, right? And that being the case, people come to see you as the face of the constituency. Then when you went there and to solicit for their votes, the community asked you, have you seen the road that you traversed to get here? Oh, especially when there was an incumbent MP that you thought was not doing very well. You would happily, I have not used the word undermine, you are saying undermine. You will happily respond that, oh, the member of parliament has been there, he's not been helping you, vote for me, I'll help you. Because you also want to get to parliament. Sometimes that's why I'm saying that by our own conduct, we also feed into it. Before we first came to parliament, we didn't have this MP's share of the common fund being given to us. But how much is that? That is supposed to serve you to do some patch work. Really is money that is given to you. There's a rainstorm in your constituency, the roof of maybe a classroom is lifted off, and you go visiting, and you realize that if you have to apply through the Ministry of Education, it's going to take a while. So you have that amount in your coffers. So you link up with the DCE and whoever, and then you apply to go and have the classroom re-roofed. The amount serves you for that purpose. There's not much. I appreciate the fact that it's increasing a bit. There are cracks in a hair facility. You use it to patch it so that it doesn't collapse on the patients who go there. So that is to the extent of the assistance that fund offers you. In terms of major development activities, you cannot help in any way. You cannot. There's been this debate over a period that because of the misconception, perhaps that amount should revert back to the assembly so that, like Pontius Pilate, we wash our hands off the issue of money being given to us for development. I have not made that determination yet. The other side is that, because the amount is so small, can we have a meeting with the administrator of the Common Fund and indeed the minister responsible for local government and have it act so that it's able to assist us in a bigger way to impact the development activities in the constituency. It's a decision that the House should come to. For now, I'm not in a position to say that it should be scrapped or that it should be upscaled to some level. It's our own decision. But let me say that we should learn useful lessons from our own conduct. I believe that if you stay in this house for 1 term, 2 terms, you have insurgents, in quotes, invading your constituency, telling them that, oh, don't keep promising that you do this. You'll not be able to do it. Give me the opportunity. I'll do far better than he is doing, right? So maybe in the flanks you can also constitute your own national resistance army, so to speak, to counter them. But it's something that we have to contend with. And we need the NCCE to help us as a house to educate the populace out there that the member of parliament is not really a development agent. But of course, as I've said, it also depends to a large extent on how we ourselves conduct ourselves in activities.
Yes. Deputy, Honorable Chief.
Thank you very much, Mr. Chairman. The Chairman, in line with the practice of this House, I think we need to let people know our leaders are usually not really taking through vigorous vetting, regardless of which ministry they are going to. And as a House, I think it's a very useful practice and we must keep it. So my intention is not to ask questions, but just to make some few comments. One of them is to say, I have worked very closely with the majority leader, and one of the main problems that we've not been able to overcome in this House is MPs being given loans to buy their car, they maintain it, they insure it at the expense of part of their salary, and how it affects the welfare of the MPs. We have, over the years, worked so hard to get the executives to understand that the arm of government, the legislature, is disadvantaged. Because if you look at even DCs, their number used to be 90, 110. Now they are 266. Only about 9 short of MPs. But they don't have to buy cars to work in their offices. The state is able to provide, maintain, fuel, chauffeur-driven. Yet in the case of the Member of Parliament, he has to go through all these difficulties. And I know how you and I and many others have worked through the committees that are set to Article 71, and unfortunately we've still not been able to overcome that challenge. Even though I know this responsibility is for the leaders of both sides, but it lies more on those of majority who are with government. I hope that as you get the opportunity for the second time to be the Minister for Parliamentary Affairs, this will continue to press home to be able to overcome it. And secondly, the President of Parliament, as you know, we've never had the opportunity to have President and Speakers that are from this House until the recent past, when His Excellency John Dramani Mahama became President, and Right Honorable Duajawo became Speaker. We thought we'd be able to overcome this. Unfortunately, we couldn't. Then came His Excellency President Nanado, and then Professor Michael Quay, and we thought that, this is another opportunity. 4 years elapsed, we couldn't. The President of Parliament will be here, and people will come in to do funerals. People will be using the banquet hall for activities, and sometimes it disrupts our own activity here. Now that you are getting this second opportunity, this is my hope that you work very hard so that we'll be able to secure our president, not only by word of mouth, but with all its documentation, so that we are sure that our president is the President of Parliament. Mr. Chairman, because of the practice, and I said we don't have to keep him long. My last comment is to say that when it comes to hard work in this House, I believe even his arch enemy will stand out for him, very hardworking. When it comes to knowledge of what we want to do, equally, many will agree with him and understand that he's very knowledgeable. But when it comes to carrying all of us along, that is where he has a lot of difficulty. I've heard him say, I've been more consultative than any other leader in this House. Unfortunately, I disagree with him. But when you come and you tell me, we want to do this and do this, So I'm showing it to you. And I give my view, you say, no, this is what we'll still do. I don't think that is consulting. That is informing. Because you've made your mind and you change it. And I think this is one of the biggest difficulties that he has. The kind of parliament that we now have. It is my hope that he will find a way to reflect and be able to manage this other part. Even I don't expect him to be an angel, but if he's able to manage that and carry all of us along, I think even though we are at neck to neck, I'm sure we'll be able to do a lot of work to make this parliament unique and make this parliament great and be able to deliver our mandate to the admiration of all Ghanaians. Mr. Chairman, this is just a comment that I want to say. And thank you very much, Mr. Chairman.
Yes. Honorable, do you want to say anything to the comment?
Mr. Chairman, I've heard you. The first one to do with MPs' loans to buy cars for official duty. And then indeed even with what we need to do to enhance the performance of members of parliament. In respect of not only the vehicles, but the procurement of official residences. Are we there yet? Even though we've improved our lot a bit, are we there yet? The provision of security for members of parliament in the face of what happened the previous administration, just before we conducted elections, there was this, so to speak, more or less knee-jerk decision to provide us with security. That's something I've been discussing for a very long time. We need to pursue it once we have the Minister of Interior in place to secure for ourselves personal security. And then, of course, again, the fourth issue will relate to evolving a pension scheme for members. So at least your mind is liberated to concentrate on your functions as a member of parliament. There are matters that are still on the burner that we must come to some determination on. The presence of parliament definition, I guess the minority that would agree with me that we've traveled indeed far on this. Just about concluding, I'm hopeful that within the next, I wouldn't say the next year, let me just give ourselves some space. Whatever it is, within the next 2 years, we should be able to come to a final determination on this, that is the presence of parliament. I agree that especially on Fridays when parliament is doing serious business, we have people dancing in the presence of parliament, sometimes mourning and drumming. And when the banquet hall was in service, there are people renting them out, and really, it's a parliament. Parliament activities going on, all manner of people flocking into the banquet hall to do whatever they deem fit and appropriate. I think if we have ownership of the presence of parliament, these will be things of the past. As I said, I am very hopeful that the next 2 years will bring this matter to a conclusion. Thank you for the compliment on public knowledge and so on. And you want me to carry everybody along. Speaker, Mr. Chairman, I'm not too sure that given my own wit, I'm able to carry the chief whip of the minority at my back. I'm not too sure that I'm able to do that, given my own wit. But, Mr. Chairman, I think that on a much more serious note, he wants a situation where everybody will have a buy-in into government policy and program. Let's face it, that is often, especially when matters relate to policy, it will be difficult to carry everybody along because the political parties differ in their philosophy. Even though in Ghana we are fortunate to have all parties being centrist parties, the MDC just being a little bit to the left of the center, MPP being a little bit to the right of the center, because the directive principles of state policy imposes on us an obligation on the architecture of national development, which all of us have to buy into. So we all belong to the center. So really when it comes to details, we may differ a bit in detail, which is why I endeavor to, as much as possible, reach out to colleagues. I think the minority chief whip has been very particular about this, and I have always insisted. I've been a minority leader for 8 years, and God is my witness. The majority leaders never consulted me on many of the programs and activities. I have my colleague here, the minority leader. You ask him whether we are not in consultation on almost daily basis. And on matters of serious national importance, I invite him to my office. We talk about these matters. Rarely do I go to his office, I must admit. But I would often invite him to my office, and then we talk about these things. But that is the level of cooperation. If I have to consult the minority chief whip, usually I route it through the chief whip or the majority. Because otherwise, if I consult you behind the minority leader, I will be undermining the authority of the minority leader. Sometimes when I talk to him, this one talk to the leader, to the chief whip. On those occasions, I'll talk to you. Otherwise, it will undermine the authority of leadership. The minority leader. When I say majority leader, perish that thought. You are not the majority leader. Anyway, so I mean that's how to the extent that we cooperate. To the extent that sometimes people think that as he keeps telling me that he sold out to the majority. And he asked me whether he's Kobe to be sold. I think we cooperate a lot. But the fact that you complain means that there's still room for improvement, and I'll take that on board.
Well, I'm surprised that a chief wanting to ask his leader question. I will save you the trouble. Honorable Minority Leader. Chairman Speaker, let me thank you for the opportunity and also to congratulate our leader and leader of the House. Sometimes he still lives in the world of the past of not wanting to carry Parliament along as its leader in the various respected roles he's played as minority, majority. But as observed by the Chief Whip, the Honorable Muntaka, and I share and associate myself absolutely with his comments that in terms of purpose, the Honorable Chairman demonstrates it. Love for his work and parliamentary business, he romanticizes that. So in the same enterprise, I do not intend to ask him any question on matters relating to character and conduct, but I envelope some issues that in the public interest, I would want him to, at his own pleasure, make some commentary for the benefit of the Ghanaian people, and for stronger and accountable parliament, and for a better democracy of our country. Therefore, not direct question, as would have been my attitude with any ministerial nominee. One, what is your mind? You've been concerned about attrition rate of parliament and us losing very quality materials. I mean, the last parliament, you've seen the like of the Honorable Banda, Honorable Musa, Fuseni, Honorable Lecturer, Dr. Asibe, and Ben Abdallah and Co. If you want to share some opinion on that, that would be helpful. Then 2, constitutional review. Where do you stand? The 1992 Constitution. Are you for a comprehensive review of the Constitution, or just pick and choose aspects of it for our purposes? Then my 3rd, you are concerned as I'm concerned. And Mr. Speaker, that will be my only question for him. The rest are commentary. This one will be my question. How do we end and manage or deal together with civil society and the Ghanaian public and political parties the monetization of our election processes and the threat it poses to the sustenance of multi-party constitutional democracy? Yes, I know all the political parties, NDC and PP, are guilty of it, but I'm using the yardstick of the last MPP primaries and the heavy doses of money with so many of our friends collapsing to that hemorrhaging cost of money. So that would be my only question for you to do. The other one would be a comment, how do we work together to strengthen Parliament? And then also to tease your mind, as I have said, I have no direct question for you. One of the weaknesses of our Parliament in the exercise of oversight is the rush with which successive governments, NDC and PP, have subjected Parliament to. You bring in a bill, you are suspending the standing orders, stakeholders are not being consulted, persons affected by the legislation or likely to be affected are not involved in the process. And you come in with a loan facility of 1 billion thanks to a public financial management system. You expect it to pass within 24 hours without scrutiny. You are free to comment on any of this. I have no doubt that you are capable of playing any role. I look forward to a better and a strengthened relationship between the executive and Parliament, but as co-equal arms of government. That is what you should lead, co-equal arms of government, not one subservient to the other or subservient to the executive. So, Chairman, I would not have, except the monetization issue, the rest, maybe he wants to communicate with the rest of the world and the Ghanaian public what his enormous experience can benefit the people of Ghana and our democracy. I thank you, Chair.
Mr. Chairman, let me also thank the minority leader, the ranking member of the committee, for the kind words. The one issue about constitutional review, he knows my opinion, and I don't believe in, just tinkering with the Constitution. I believe that there should be a holistic review of the Constitution. We are in Parliament, we have applied the Constitution, and indeed we apply it on a daily basis. We know the weaknesses that confront us in many areas, including even what he is alluding to, the process of amending the Constitution, especially the entrenched ones, which seem to relegate the Parliament to the backyard. Even with the non-entrenched, what's properly defined. So
Parliament as an arm of government will have many issues. You even speak about the bringing agreements and bills to Parliament, and sometimes we have to set aside some of the orders. The Constitution is always a bit confused about what to do when we have to abridge the process. You would realize, my colleague, that when you refer to Article 106, I think, Article 106, which deals with the mode of exercising legislative power. Just look at it. When you come to Clause 13, which provides where it is determined by a committee of Parliament appointed for the purpose that the particular bill is of urgent nature, the provisions of the preceding clauses of this article, other than Clause 1 and Paragraph A of Clause 2, shall not apply, and accordingly, the President shall give his assent to the bill on its presentation for assent. What does it mean? What it means is that the Article 106.1 would apply, 106.2 would apply, 2A would apply. It says the preceding clauses except 1 and 2A. So the publication in the Gazette will not apply. And when we thought that is the main issue, if you come to 3, it talks about a bill affecting the institution of chieftaincy shall not be introduced in Parliament without prior reference to the National House of Chiefs. Does it mean that in an urgent situation, one can waive that? 106.3, there's that unclarity. 106.4 then relates to the processes. That is first reading, second reading, the constitution stage, third reading, and so on. It says that all these should be suspended. What does it mean? How does the bill enter Parliament in the first place if it is not read for the first time? So there's that unclarity and confusion. And I think that we should have a holistic view of this, of the Constitution. In much the same way, if we relate it to the judiciary, they'll have their own issues. The constitutional creatures. You remember my distinguished colleague, when at a point in time we had to the president had to bring in Charlotte Osei in place of Afarijan, who had retired. My position at the time was that we should have the president submit the names to us for Parliament to subject it to prior approval using 2/3. When you come to Parliament approving by 2/3, the president will be forced to be very much more consultative in the appointment than is usually the case. That was just a suggestion. Today, commissioners and commissioners who are appointed by the president are undermined because of maybe lack of trust. And the NDC thinks that because the current commissioners were introduced by President Akufo-Addo's regime, they cannot trust them. Just as we thought Tamasai's commission could not be trusted. What should be the way forward for us as a country? Or should we go on in this haranguing all the time when there's a new set of commissioners? I think there should be a better way for us as a country. And as I'm saying, if we left it to all of us, strand out the critical issues contained in the Constitution and elevate them to a national debate from which perhaps will be born a consultative assembly or constituent assembly, then something could come out which we shall subject to referendum. And then whatever the agreement is, that will be the new Constitution for us. So I think that it should not just be a tinkering with the Constitution. There should be a holistic. and indeed wholesale review. The issue about high attrition rate and monetization of the election process, you've heard me, the Honorable Ranking Member and Minority Leader, on many, many occasions. I think that there's no person in politics who is a Father Christmas, and I keep insisting on this, that in politics, when people show today, they will not have the patience to wait until 1 year or 2 years before they want to harvest. They sow today, they want to harvest the day after today. The process, we should all admit, is from the very beginnings, where we engage in, my party engages in the election of polling station executives. That's where it starts from. Then we come to electoral area, then we come to constituency, then we come to regional, then we go to national. I refer us to Article 55(5) of the Constitution, which provides that the chairman, if you permit me, 55(5), which provides that the internal organization of a political party shall conform to democratic principles and its actions and purposes shall not contravene or be inconsistent with this Constitution or any other law. On account of this, some people think that at every level of the structures of the party, there should be elections. I disagree. Because the same article in clause 9 says that the members of the National Executive Committee of a political party shall be chosen from all the regions of Ghana. Now, by these elections that we conduct, how are we able to constitute the National Executive of a political party to reflect membership from all the regions in this country? We're not able to do that. Yeah, good. The language in the Constitution is they shall be chosen. Of course, election is one means of choosing people. But election is not the only means. Popular acclamation is a means of choosing. Appointment is a means of choosing. So until we come to some understanding on this, we shall have problems. And it reflects in choosing parliamentary countries as well. In the established democracies, at the end of the term of a parliament, nowhere in the established democracies do you have what is happening in Ghana, that the sluice gates are opened and anybody can enter. Democracy everywhere is guided and guarded. And until we come to that understanding and open the sluice gates every 4 years, this monetization would become difficult for us to banish it. Because elsewhere, the parliamentary parties assess the performance of the MPs and pass on the recommendations to the party. This person is doing so well. And Minority Leader, you mentioned a certain person called Ben Abdallah. You know what he was doing for this house and for country? He spoke about Dr. Sibeyeboa. And
powers and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at
It's going to be fun to see how he goes about approaching this game.
280 plus 1. And I can see it could be an implication into of the mandates there, the mandate to make recommendations. Well, it says to report in writing the results of the inquiry. If indeed the Commission of Inquiry comes up with a report and says that the results of our inquiry review, systemic failures at, say, your constituency, I want to mention, yes, Boku Municipal Assembly. And I think that it will be incidental, only incidental to such a function to say that in order to cure the systemic failures, we are recommending A, B, and so. But that is why it is called recommendations. They're not binding on the government. Recommendations are recommendations. They just mean exactly what the word stands for. And the government can decide to disregard it if it feels so obliged.
Supplementary to that last
Thank
question.
you very much.
No, supplementary to that question. Chairman, supplementary, you said we could have...
Thank you, you've had enough.
Supplementary, yes. No,
Honorable Chief Whip, now, you know, we have a longer long run coming, so please. We've had how many hours? 5 hours now, and we're still running.
Thank you, Mr. Chairman. Mr. Chairman, I'm not a lawyer, as my colleague, the nominee, will know. But I was enjoying his interpretation to the Balkan ruling, where he was talking about the court and his views when the court talks about major agreement. Once it's not a major agreement, it doesn't require parliamentary approval, and in his giving meaning to that, he is saying that major agreement means it's not driving from it's not the primary agreement. Is that right? So you are saying that, in your understanding, or you are claiming that that is the court's words, saying that major agreement means it's not a primary agreement, or you are giving that meaning to that?
Mr. Chairman, that was the position of the Supreme Court of Ghana.
Did they describe or define what they mean by a major agreement?
Mr. Chairman, as far as I recall, that was so.
Can you refer us to that? Because as far as I'm concerned, they did not define major agreement. If you claim they do, I'll be happy for you to quote where the Supreme Court defined major agreement to mean.
No? No? Mr. Chairman, so you will see at page 1033 of the decision of the court as reported, 2012 Volume 2 Program Report at 99, that said that the framers could not have intended the obvious and foreseeable paralysis from overload in Parliament that will ensue from interpreting the provision as covering every single business or economic transaction with an international dimension. The implication into Article 181 Clause 5 of the attribute of a major before a transaction enters into its ambit would thus seem to be necessary and reasonable within the spirit of the Constitution. And then at page 1035, it says that examples, okay, so the defendant's hypothetical analysis shows a sample of many other transactions which could literally be brought into the semantic umbrella of international business of foreign transactions, but which should not be so construed for the purpose of Article 181 Clause 5. Examples would be documentary letters of credit and for international sale of goods. The framers did not have in their contemplation subjectively or objectively transactions of ordinary commerce. Mr. Chairman, so clearly the Supreme Court indicated that transactions of ordinary commerce, like documentary letters of credit, and the example that stated there, should not be transferred
So you agree with me that when you were saying that the merger agreement, in your definition, was is not the primary agreement, was your interpretation, not what was the test. Because all these tests that you read, nowhere did it say that merger agreement means what is not the primary agreement.
It is so, because indeed in that case, they actually construed matter to be in reference to the agreement that was subject matter of the dispute. And that agreement was the main power purchase agreement. They indicated so, that by virtue of it being the main power purchase agreement, it ought to be a major agreement. And I'm saying that they went on in the part of it to show that ordinary agreement.
Yeah, it was only examples that it was given.
Yes.
But it didn't say that once it's not a primary agreement, it's not a major agreement.
No, but the examples, were a consequence to their holding that the power purchase agreement in question before the court, by virtue of it being the main agreement in issue, constituted a major international business or commercial transaction.
Well, in the case of the special prosecutor and his view, I tend to agree with him because I see that to be major. Because if you have a South African company that is going to be advising us in a commercial agreement that is virtually determining our net resources, a chunk of it of as high as $750 million. If anybody says that this is not major and therefore doesn't require parliamentary approval, I disagree. And I want to agree with the what we call the special prosecutor. I mean, obviously, that's why we all have our opinion, and probably until the Supreme Court makes a definite determination on this, we could all continue the banter. But I can tell you that for somebody to be involved in such a quantum amount of money advising, obviously that is major for me.
The mandate agreement was not worth $750 million. The highest extent, that is only the event of success, was $4 million.
You're talking about
the main agreement, yes, was $750 million. I agree, and that is why it came to this honorable house. But the mandate agreement, the value of it, the payment and the mandate agreement were only $15,000 a month. And I'm saying that the highest amount that could have been obtained after a success of the transaction was $4 million and nothing more.
I'm not talking about their charges. I'm talking about advising on the quantum of what they're advising. That's what I'm talking about, the 750, because that's what was involved. I'm not talking about what is going to them. I'm talking about what was at stake for them to advise. And if, for example...
if that is the case, then when the government of Ghana hires external lawyers to defend its interests in the matter, which has at stake $1 billion, by virtue of that, the hiring of a lawyer ought to be international business or commercial transaction. But we hire lawyers all the time. Since 1992, the government of Ghana has hired lawyers for international arbitration. None of them has come to the Honorable House, even though the lawyers that are hired are foreign lawyers. It is only our time, the last 4 years, that our international lawyers, our lawyers for international arbitration, were Ghanaian.
I don't dispute that. And it's like the example that you're giving, because some people have been doing something wrong and have not been bringing it, it makes it right. No, it doesn't necessarily make it right.
What I'm saying is that if this line of reasoning, is correct, then it would imply that merely because a lawyer is advising a transaction worth $500 million abroad, by virtue of that, the appointment of the lawyer, apart from PPA approval, also ought to be a side matter of agreement. I'm saying lawyers are hired by government of Ghana all the time abroad, and none of them, even though the lawyers are foreign, has had the agreement being a side matter.
And that's why I was telling you that if it's done, and I believe it's wrong, because if somebody is going to advise us on something that is $1 billion, the representative of the people need to know. Because if the person wrongly advises us, we could lose the $1 billion. So I'm looking at the what is at stake, not how much is paid that person. But anyway, in an earlier answer to your question, you claim that the special prosecutor did not give the parties hearing. Is that what you said?
That is so.
But do you have on records, or you know for fact that he has given an opportunity to write response to him?
Chairman, I have on record letters written requesting for documents to assist in an evaluation of the transaction by the special prosecutor. But there is nothing on record showing a grant of a hearing before the determination by the special prosecutor. And I think that if indeed you're evaluating documents and after your evaluation, you think that there are certain findings and you make comments and conclusions which border on wrongdoing against a specific public officer, it is only right that you grant the public officer a hearing before you go ahead and make those findings. That is an established rule of law and it's a fundamental human right. It cannot be done with.
Mr. Chairman, I'm not a lawyer, but I want to believe that if there's an issue and you give me the opportunity to write, to explain myself, that's not hearing.
No, Mr. Chairman, there was no, that's the issue. There was no letter written by the special prosecutor asking A or B to respond to this issue or to say, explain why there was no parental approval or why there was no PP approval or why Chancellor Dubois signed. Definitely not. There was rather a request for documents, and that is not the same as the grant of a hearing. So the grant of a hearing must be construed substantively and not just.
Yeah, Mr. Chairman, in an earlier answer to a question, you also said that Databank had been involved in transactions with the Ministry of Finance and government agencies, since President Kufuor's time. Is that right?
Mr. Chairman, since President Rawlings' time.
Okay,
right
since President Rawlings' time. You said that. And you went ahead to say that during President Kufuor's time, they were involved in sovereign bonds, Dera Tamils, Mahama, and now. Did I hear you say that?
Mr. Chairman, I think that is the record.
Can you refer me to any of such transactions during the President Mo's time? Because between 2009 and 2012.
Mr. Chairman, I'm aware that that's actually contained in responses that were filed by the. But so I think that it's at this point necessary to indicate that, Mr. Chairman, I am aware of a letter dated somewhere in January written by the special prosecutor, the acting special prosecutor, eliciting comments relating to events about the circumstances of the transaction. The transaction was the Japan transaction. And in that letter, the special prosecutor indicated that he was preparing to conduct a preliminary inquiry. So that even affirms the point I made earlier on, that there was no such grant of an opportunity. Then the Ministry of Finance, I'm aware that they wrote to the special prosecutor.
No, my question to you is with regards to data bank.
Yes, so I'm saying that information, that information was disclosed in the responses of the Ministry of Finance. That's how I came by the information.
And I know that between 2009 and 2012, I was in this house. There had never been the time where we had to resort to bond, a sovereign bond.
I'm not in a position to affirm the truth or otherwise of
but you said that
the official report.
What I'm saying is that you have said here that Databank had been involved in financial transactions with the Ministry of Finance during this period. And I'm saying that, tell us which transaction was this?
Mr. Chairman, I can produce to this honorable court, I'm sorry, Mr. Chairman, I can produce this honorable committee a copy of the memo written by the Minister of Finance to the Special Prosecutor in January 2021. And that statement is contained in there.
So you finished this committee with that fact?
Mr. Chairman, I'm quite so.
Are you aware the method that was used in procuring the services of Databank in the last 3 Eurobonds as a transaction advisor for Bucharest?
more aware of the method
of procuring, how they procure them, because you also sit on the board of program authority.
So,
was it through sourcing? Was it advertised? Was it through competitive bidding? What method did they use?
Mr. Chairman, I'm not aware. As I said, there are hundreds of transactions that, unless I don't keep record of it, I have no interest in any of them at all. The only transaction regarding the issuance of bonds that I am aware of is the first bond, a $2 billion that was issued by the Ministry of Finance, and I'm aware of it. I remember the fact because it led to the report of the Commission of Inquiry, whether there was conflict of interest regarding the conduct of Mr. Kenufrata. And the Commission of Human Rights and Administrative Justice made a determination that there was no conflict of interest involved in the conduct of Mr. Kenufrata in that transaction. Subsequently, I had an action in court challenging aspects relating to the conduct of the Ministry of Finance and Bank of Ghana, which bordered actually, which instead of it was no grant of a hearing, and the court appealed it and quashed it. That's what I'm aware of it.
So this very one that you are aware, the services of data bank, was it through competitive or sole sourcing?
The Chairman, service of data bank, I don't recall were used. I think that it was, the allegation was in relation to a person who was a director in Enterprise Insurance Company and was also a director.
FT. Is it not FT?
Pardon?
FT.
FT is what? Franklin Templeton.
Yeah.
Yes, so the person was a director in Franklin Templeton. So the honorable member is aware of all the facts. I don't think Data Bank was involved in that.
Okay. In the case of the 2013, Data Bank won to be the advisor to government in that sovereign bond through competitive bidding. That went through all the process and they won. But unfortunately, you say you are not aware of the processes that got them to be part of the other transactions.
And again, they won competitively. And I don't think that there has been any impugning of the role of Mr. Kenufrata as regards that transaction.
Mr. Chairman, the nominee is a board member of the PPA, right?
Mr. Chairman, yes.
How many other boards were you serving when you were the Deputy Attorney General?
Mr. Chairman, about 3, the Ministerial Advisory Board of the Ministry of Justice and Office of Attorney, the Legal Services Board, again of the Ministry of Justice. And then there's another board which I'm happy that you brought up, I forgot, recently last year, the University of Ghana Medical Center Board. I'm also a member of the board.
So you are on about 4 boards, state boards?
Yes, you said how many other boards? I said 3 other boards.
What is basically your role as the representative of the Attorney General on these boards?
The nature of my role as Attorney General on the PP board. First is to, I'm sure the law anticipated that because really the matters that the Public Procurement Authority does are essentially legal. Approval of the various methods of procurement legal, ensuring an implementation of the PPA Act, ensuring compliance by various procurement entities with the PPA Act. These are legal. So I anticipate that's the reason why the law requires the Attorney General or his representative on the board. And conventionally, it has always been a Deputy Attorney General. My predecessor was a member. And I'm proud to be a member.
Sure, but so largely it is just to ensure that they comply with the laws.
The Legal Service Board, as Deputy Attorney General, is required to be on the board.
So how did you receive the investigative piece by Manasseh Awuni Azure on this contract for sale, knowing very well that you were on this board? How did you receive that piece of investigation?
Chairman, I answered the question earlier on, and I said that it was a surprise that I received it.
Did your board, did you know that the companies were involved in some of these things?
Chairman, the first time I ever heard of any company called Talent Discovery Limited was when Manasseh Awuni himself, as I indicated earlier on, called me and sought a meeting with me and told me about his own finding in the course of an interview that he had elicited of Mr. Ibieje.
Do you remember that the board secretary, that's the legal and board secretary of PPA, Mrs. Leslie Dodu, wrote to the SRAD claiming that, yes, he disclosed his interest to the board, and therefore he recused himself anytime his companies were before the board. Is this something that you can remember was on the board?
Mr. Chairman, I remember that, yes, the board secretary wrote that Mr. Ibieje recused himself in respect of one transaction, and that was the finding of charge as well.
And when he was recusing himself, what excuse did he give?
Chairman, I think the record shows that I was not even at that meeting. I stand for correction, but I think the reading of charge indicates the persons who were present at the meeting. I don't think I was one of them.
Are you
but reading the charge ruling, he indicated that he was a shareholder. I think so.
Are you saying that that particular meeting you were not in attendance?
Mr. Chairman, I think that is what the charge ruling actually came up with. My name was mentioned as attending only one technical committee meeting. All the others, I was not there. I indicated that the technical committee meetings, most of the time I'm not even there.
No, but unfortunately, the SRAD report indicated that you were in the meeting. That this lady wrote to claim that he recused himself.
Then I'm very happy, because if indeed I was at the meeting that there was compliance with the law by Mr. J, then I'm very happy.
But you just said just a moment ago that you
I said that I remember the SRAD report said I was present at only one technical meeting. The number of meetings that I referred to, I think it was only one that I was present at.
My question is, you just said that you were never aware that he had companies. You just said that.
That's about hundreds, I told you, hundreds of applications.
No, it's not about the hundreds. It's about you sitting there and the CEO says that because this company have interest, I'm recusing myself. But you have earlier said that you have never known that you had a company.
As far as I did not recall at all. Because definitely that meeting, I'm sure, was 2017 or 2018. And Master Awoni's work was in 2020. If the facts are right. It was about 2 years later. And I don't even remember. It's only when one takes a personal interest in these matters that you will have all these things in your mind. And I had no personal interest.
But you know that it's the CEO that prepares and reviews all the tenders before it comes to the board. You know that that's how it works at PPA.
Yes.
So recusing himself from the board meeting in Africa doesn't take away the influence of insider trading and knowing what you call the quotations are in preparing the letters to the board. So recusing himself at only the board does not really exonerate him or take the burden of him having undue advantage and conflict of interest situations in there. So when he recuses himself and the board members, you think that is enough? Don't you think that it will not be fair to say that the board members are not culpable of the crime that he committed?
Precisely. Chairman, the 2 points. First and foremost, the duty to evaluate applications for research and all single sourcing applications rests with the board solely. The CEO only conducts an assessment of the compliance with the statutory documents. I mean, whether indeed some statutory documents have been furnished by the relevant applicants. So the CEO will determine that the companies that have been shortlisted had sales net, had VAT. The actual consideration of the merits of the application is done by the board, and that's the board's duty. So, even that function of the CEO is only recently, it's actually not in the law. So a CEO can just submit the application straight away to the board, for the board itself to determine whether each of the companies that have been shortlisted had statutory documents or not. And because, as I indicated, 100 applications come, clearly it will be onerous and unreasonable to expect a committee of the board sitting from say 10 to 12 or 10 to 2 to be evaluating all those documents to see whether the statutory documents are in order. So I think that first and foremost, the role of the CEO in this must be clearly understood. It is the board which actually carries out the function of determining the propriety of an application. And secondly, charge itself determined whether there was compliance by the board or a violation by the board of any rule, and came to the determination that the issue was actually about Mr. ABJ. So I do not think that we can challenge.
I thought the SRAD had not said that, because currently the Ghana Integrity Initiative is, earlier you said it has to do with only asset declaration. No, that's just one of it. It also has to do with the board, and they are preparing a report on the board too.
Mr. Chairman, Mr. Chairman, if indeed that's the case, then I think that it will be prejudicial, this discussion about whether there's conflict of interest or a violation of a rule or a duty by the board, will be prejudicial to the work of SRAD.
Not necessarily. I mean, our orders are very clear. It's the chair who determines that.
Mr. Chairman, I am unable to comment on the matter which may potentially result in prejudice to the work of a constitutionally mandated body.
Mr. Chairman, in an earlier answer to a question answered by the nominee with regards to Unibank and the initial preliminary observations that he made, as he claimed that subsequent letters and explanation came and little to say negated some of his concerns in those letters. But he will agree that the date for the establishment of the CBG and the date that it was given certificate, that you commented that giving them class 1 certificate to operate as a bank was wrong. That has nothing to do with...
Honorable, he has answered that question being read to him in full.
No, he said because the letter provided better and better particulars, it made those concerns virtually like irrelevant. But I'm saying that if you look at the date those things were, the bank was established, it's a fact that they breached the law. And I couldn't imagine any explanation that can undo that concern that you had.
All issues regarding the legal propriety of the incorporation of CBG are the subject matter of arbitration by Dr. Dufour and his directors. Again, all issues regarding the propriety of the decision of the High Court judge to refer the matter to arbitration are also pending in the Court of Appeal. I do not think that it would be proper as a nominee for the position of Attorney General Minister for Justice to be making further comments on the matter. Otherwise, I'll be doing injustice, rather.
Mr. Chairman, to a question on the Frontier Health Services Limited. He said because of the numerous documents that passes through PPA, I mean, he cannot recollect anything on that, right? But you've subsequently had this being discussed extensively, I mean, in the public domain, and it keeps coming again and again. The airport, what is happening at the airport, those who are there, they've not gone to the law, and the Deputy Attorney General, you have said that you never took interest to know exactly what was happening there.
Mr. Chairman, to be honest with you, there are many aspects of the award of the contract for testing COVID-19 patients. Am I correct?
Yes, at the airport.
At the airport. Some relate to the price no, that go on there. The very first time I actually took note of this particular issue was when the Minister for Health, the nominee for the Minister for Health, appeared before the House, and I heard that there was an issue of procurement about it. Apart from that, I've not heard that.
Mr. Chairman, I just want to find out from the nominee, in an answer to an earlier question on Gregory Afoko, you said that he couldn't meet the bill condition. Is that really what you said? Didn't meet the bail condition.
Yes, originally. And subsequently, there was a fresh charge of murder preferred against himself and the other accused person who had been arrested in Côte d'Ivoire. So the High Court judge in the second matter revoked the grant of bail, and the matter is before court. It's a jury trial.
So you are now clarifying that he was later able to meet his bail condition.
That chairman, I've not said that at all. I'm unaware of it.
Are you aware that he was able to meet his bail condition along the line there?
I'm unaware, and indeed I'm not surprised that I'm not aware, because we have two deputy attorneys general. My remit was largely civil. That's why you don't find me in any of these criminal matters.
I want to find out from the nominee, who is your personal escort?
Chairman, my personal escort as in security provided by the state.
Yes.
Chairman, my escort is provided by national security.
Is he a police officer or a military officer?
At various times, there has been a revision of the security around me. In the early stages of my service in office, I even had no security. And subsequently, I was given a policeman. At another time, it was changed to a military officer. At another time, it was changed to a police officer. Well, the chairman, so the security that I get at every point in time is assessed. In fact,
I just asked whether he was a police officer or a military officer.
So, yes, until I can't discuss, well, until it, I was even going to say that at one point I even had no security at home. But I think that it's a revision of that, and I don't want to disclose further details.
No, I mean, this is a public hearing. I'm asking you, the escort that you currently have, is he a military officer or a police officer?
Chairman, I think I've explained that sometimes it's police, sometimes it's military.
Mr. Chairman, I'm not talking about the sometime, I'm talking about now. No, let him answer them. Let him say he's not in office.
Chairman, my security is revised now and then, and with all the greatest respect, I would want to.
It's a military officer that
no, I'm saying that especially at this material time. You remember I made references to the past, in the past, because really those are matters of the past, and nothing can be done. But now, I think that in order not to, with all respect, and compromise any kind of security.
No, because you walk out now, everybody sees him with you. It's not a matter that is hidden. Neither my escort is hidden. Mine is a police officer. Yours is a military officer. And he's been with you for about 3 years.
Gentlemen, I remember that the Minister for National Security was asked questions on this line. Secondly, the Minister for Defense was also asked questions on this line. And I think that if indeed the House, with all respect, requires details of such matters, it can be elicited, but not on camera and before national television.
No, because our citizens are concerned about the militarization of our society. And
Honorable leader, I think his personal security is being put into issue here, and I think it's safer to leave it here.
Mr. Chairman, it's not about his personal security, it's the one that the state is providing to him. Just as you and I, everybody sees us. When we walk out, everybody sees those who are
yes, for his personal security.
This is not something that he cannot hide, Mr. Chairman. This is what the state is providing him.
Without due deference to you, I'm not saying he is paid or paying for them. I'm saying that his personal security now is being put into discussion, and I encourage you to move on.
Mr. Chairman, in an earlier answer to a question about the payment of compensation to the Iowa West Rogan with regards to Emil Short's report, he also made an assertion that because the commission didn't determine the quantum, that has been the reason why payment has not been made. Is that right? Is that what I heard?
I said first that I was not the attorney general, I'm still not the attorney general. And perhaps there might have been reasons why that recommendation has not been implemented in the white paper signed by the attorney general. And I made reference to the fact that the civil liability law, I will examine the civil liability law and see whether those concerns that I anticipated to be the cause of the default in implementing the recommendations have been resorted to, and that I will endeavor to ensure that the conversation is worked out.
Well, when we were vetting both the Defense Minister and the National Security Minister, they created the impression that it's the Attorney General's office that has worked with the Finance Ministry to resolve that.
I heard that. Indeed, I heard that from the two.
Can we take your word that if you are approved to become the Attorney General, this is something that you expedite action on?
That's why you have my word, and I'll do so promptly. Work with the Finance Minister and work out reasonable compensation.
Mr. Chairman, last but one. The road in the presidential transition team report, to be precise, report of the infrastructure subcommittee of the 2020 presidential transition team. Mr. Chairman, with your permission, page 19, paragraph 4.6, with respect to the Accra Intelligent Traffic Management Project. This is what the transition team report is saying on paragraph 4.6. Termination of the agreement between the Ministry of Roads and Highways, represented by the Department of Urban Roads, and the Beijing Everyway Traffic and Lightning Technology Company Limited for the Accra Intelligent Traffic Management Project. A contract was signed in 2018 for the project, and the two interim payment certificates has been raised, which are yet to be honored. However, through government policy, a new agreement for the same services was signed between the government of Ghana, represented by the Ministry of National Security, and Huawei Technology Company Limited, and the China National Import and Export Corporation. Are you aware that this company that the contract was taken away from is at the international arbitration seeking redress?
Mr. Chairman, the international arbitration never came to my attention before 6 January 2021. And I've also not received the handing over notes. I believe that if this Honorable House approves of my nomination, I'll receive the handing over notes, and then I'll take the due steps to ensure a resolution of whatever dispute there is.
Mr. Chairman, let me leave it here. Thank you very much.
Thank you. I'm skipping the minority leadership. I'm skipping you. Or you want to ask? Yes.
Leonard, the general view is that you are doing well. And from a disco, perhaps if you had gone to St. Augustine's, it would have been better. But that's okay. You'll get the next opportunity from your children to be there. Anyway, the banking sector cleanup, it cost this nation so much money. Billions were paid to investors who have lost their investment. Ghanaians are expectant that some investigation, some prosecution will take place, especially so when the view is that some of these investments were not properly done, as in the directors and the shareholders not having properly invested people's funds. And now government had to pay over 22 billion cedis, monies that could have been used for roads, improved healthcare service, improved infrastructure in our schools.
So what assurance can you give to Ghanaians with regards to investigation and prosecution?
Mr. Chairman, I think that it is necessary to place on record that there are 3 major cases regarding the banking sector cleanup. The first is Republic versus William Atracian and others. It involves charges for the offense of stealing. The second one, Republic versus Dr. Komna Dufour and others, charges of fraudulent breach of trust and dishonestly receiving. And Republic versus, that's the UT Bank one, Amabin or so, I'm sorry, involving offenses of fraudulent breach of trust and dishonestly receiving. The same one, I recognize that there's a need to, of course, as part of the efforts to ensure sanity in the banking sector and to ensure financial discipline generally, and take steps to punish offenses committed in relation to the banking sector. And that is the only way that we can boost investor confidence and protect investment and deposits of the general public. So I would take all the relevant steps that are necessary to ensure that we investigate any dockets that are available.
Can you also give assurances regarding asset tracing?
The Chairman, that's an area that is of serious interest to me, because I deplore the situation where the people commit either wrongs or crimes, and executing the judgment in relation to them becomes so difficult. I have had this situation, the Woyomi matter, for instance. I've been trying to trace assets for the past 4 years. Fortunately, recently we were able to raise just about value properties, sell properties, the value of about 18 to 20 million. We are still tracking or tracing the assets. So I will institute measures and strengthen the laws of Ghana to ensure that the investigative institutions of state are empowered to effectively trace and track assets of Congress.
Leonard, if you have your constitution with you, Article 210(3), I read, the armed forces shall be equipped and maintained to perform their role of defense of Ghana as well as such other functions for the development of Ghana as the President may determine. You know, in this discourse, our colleagues on the other side particularly have been raising issues, you know, seeing the military and all that, even having to question why VVIPs or VIPs are given protection sometimes by the military, why some businesses or some installations have military presence. It appears that the reading of the function of the armed forces is often limited to the defense of Ghana. With the benefit of the full rendition or the provision under Article 210(3), can you elaborate further of your understanding of the general role of the armed forces?
The letter, I think the letter of the provision speaks for itself, and it says clearly that the armed forces shall perform such functions as shall be equipped and maintained to perform their role of defense of Ghana as well as such other functions for the involvement of Ghana as the President may determine. The President is the Commander-in-Chief of the Ghana Armed Forces, and for that matter has every right to, with all respect, determine the manner in which the armed forces operate, and that is clearly constitutionally expressed in Article 210(3). Further, I will refer to the National Security Council provisions, Article 83, Many a time people think that national security is actually some armed force organization. The national security is not an armed force organization. It has constitutional backing. It is set up by 83, and the committee will note that the National Security Council is made up of the entire armed forces plus other security agencies. So the Chief of Defense Staff is usually a member of the National Security Council, the IGP is the Director General of the Prison Service, and the fastest National Security Council in Article 84 will also show that they also have serious responsibilities for taking measures as are necessary to safeguard the internal and external security of Ghana.
So Council, from what you have just told us, I will be right in saying that anybody who limits the functions of our military, the armed forces, strictly to the
defense of Ghana,
functions of defending the territorial boundaries of Ghana, to be wrong. Anybody who thinks so is totally wrong.
That would be a narrow view of the constitutional provision.
Narrow view.
Narrow view of it.
Very well. Now, let us look at Article 1815. We've had a general interest in that area. Would you strongly recommend a legislation to further address the lacuna in aspect of the said provision? Because, for instance, my colleagues were having a banter with you regarding your view of the phrase major transaction.
Yes.
Don't you think that a legislation in that regard, as recommended in one of the cases by the Supreme Court, will help?
Mr. Chairman, that will be a positive step in the right direction. And it is actually on top.
Honorable Deputy Leader, if there is no issue to be clarified, I want to come to the leader so we can save time. We've done 5.5 hours already. Not one. Come on. Not running. Do one more, colleagues. You, I can believe you, not the others. I can.
As it pleases you. As it pleases you.
Chairman, so I will initiate such a decision. I think that it is high time that Article 181 Clause 4 be implemented by the Honourable House. Because the provision enjoins Parliament to enact an act of Parliament to provide for the particulars and the modalities for implementation of 181 Clause 5.
Regarding Ejapa, Honorable nominee, the mandate agreement, which was between Imara and Ministerial of Finance, did not include Data Bank as a transactional advisor. But in that agreement, there was a mandate given to Imara to further engage other advisors for the purposes of achieving its mandate. Is that correct?
Chairman, I think that is a little wrong because both Imara and Data Bank were engaged as transaction advisors from the parties. The commission. The agreement is made between Minister of Finance and Imara Corporate Finance Limited and Data Bank, together referred to as their transaction advisors. But of course, I agree with you in respect to the second part of the question that they had been given a mandate. Imara had been given a mandate to engage other service providers.
Yes, and you had said that regarding that transactional advisory role, this is not the first time Data Bank has had to provide that services. I know that as a fact because I was here in 2015 when Honorable Secretary was coming for Eurobonds. I was a member of the Finance Committee, and I know for a fact that Data Bank played diverse roles in that
Eurobond. I don't know of previous, but at least I know that during Mahama administration, that happened. Are you saying that the form and nature of that transactional advisory services provided then is same or similar to that which was required of data bag in this transaction?
The Chairman, definitely the scope of the agreement may not be the same, but the essence and the substance are quite clear. That first, because the appointment of the transaction advisor did not constitute the main agreement, the legal position will be that it did not have to cite for parental approval. Secondly, that it is not uncommon in international commerce to have a transaction advisor be given the right to appoint engaged service providers, which will help in the attainment of the work that the transaction advisor is supposed to do.
So, in other words, it was Imara that brought in Data Bank as one of its advisors.
Yes, Imara, this will pursuant to the rule of the tender process. The tender process required that bidders ought to come with local partners. And so the other bidder came with another local partner. So that rule, as I indicated, was not discriminatory. And there was no violation of any procurement law provision, as far as I'm aware.
Okay, so in rounding up, have a bite on this. Shraj investigated this ABJ matter. Now, would you say that in their investigation, they didn't see the need to invite any of the board members, including you?
The Chairman, the entire board was invited, as I indicated. The board actually gave their comment, and I think that individual even wrote. Apart from that, the board chairman and two other members appeared personally to testify. That is why I make the very confident conclusion that if indeed there was wrongdoing on the part of any other board member, that would have been made out in the report.
So, Honorable Leader, I thought we agreed that you round it up so that we'll have saved some time. And it has not been the practice for the vices to be this long.
So would you say you've made some progress regarding management of judgment debts? I mean, not you as a Deputy Attorney General, but the Attorney General's department for the past 4 years.
Chairman, indeed, we have. And I can cite other instances apart from this Tony Wolome matter. There is the African Automobile against Accra Metropolitan Assembly and the Attorney General, which resulted in the state avoiding an amount of, will you believe it, about 153 billion Ghana cedis. The state also is currently in the Supreme Court challenging the payment to NDK Financial Services, a sum of about 1.5 billion Ghana cedis. And we have also avoided numerous damages. They have all been made out, as far as I'm concerned, in the report.
Just for the record, when you mention 1.5 billion, tell us the purpose. What we are seeking to retrieve.
Because that matter emanated from the issuance of a security by the Minister of Energy. And it was just for the sum of about 263,000 Ghana cedis as a result of compound interest that was calculated on it. The company is currently claiming about 1.3 billion Ghana cedis from the government of Ghana, in spite of the government of Ghana having paid 79 million Ghana cedis. So we are in the Supreme Court. I myself argued the matter. I said that the money that the government of Ghana has paid, 79 million Ghana cedis, should be considered as full and final payment because it is inequitable and what have you.
Okay, Mr. Chair, finally, then I'll raise my case. PDS.
But there are other matters that I cannot recall.
On PDS, there are two issues I need you to clarify for me. You run us through the history of the transaction, MEDA, MCA, and that when the new government assumed office in 2017, nothing new was done except to create a new imbalance in favor of Ghana, that 51% ownership should go to Ghanaians.
That's against 20%.
Yes.
Early on.
Yes. And it was, you contended that you really didn't change the structure of the bid, whatever had been done, as to which companies participated. This government did not do anything. Is that again your contention?
Yes.
And finally, on that PDS, isn't it the case that some third-party entity, other than agents or institutions of government, rather did some enhanced due diligence that resulted in this fraud, which was detected in Qatar?
No, that one was actually ECG itself, was the board and the CEO of ECG which undertook to ascertain the authenticity of the demand guarantees that had been issued. And they kept writing to Output Insurance, and that culminated in a discovery of the wrongs that had been committed in the issuance of the demand guarantee. So it was actually an effort of ECG, and they must be commended.
All the public comment about supposed alleged corruption on the part of government were just misplaced and had no basis in law at all.
Mr. Chairman, there's actually no basis at all for any allegation of fraud or corruption to be made in this transaction. The facts are clear, as indicated. It was the validity of the demand guarantee issued by PDS, and it was as a result of an inquiry by first ECG, the President's initiative in setting up a team to go to Qatar and to go to the United States of America, which established violations by PDS, and that resulted in termination. That's also a matter pending in court.
Chairman, thank you so much.
Honorable Minority Leader. Speaker, thank you very much. I note that we have subjected the nominee to proper scrutiny as a committee, and I can appreciate that he's been sitting long with the family. But advisedly, because of Article 88 and the onerous burden, mandate, and authority of the Office of the Attorney General, let me just take you where my colleague left you. Do you have any evidence of a correspondence to PDS giving them any opportunity to have rectified the agreement per the contract with the power purchase agreement with ECG under the private sector participation? Was there any formal correspondence to PDS and an opportunity given them to rectify the demand guarantee?
Mr. Chairman, indeed I do, and I'm also...
Kindly submit that for our purposes. That's enough for me.
Sure.
And in respect of PDS, is there any claim by any affected party for judgment debts that you are aware of? Any action or claim for judgment debt by any of the parties affected following the suspension or termination of the transaction?
No, I'm actually just aware of one case that has been filed by PDS against the Attorney General pending in the High Court.
Did the state of Ghana lose any money per the Millennium Challenge contract as a result of the handling and termination of the PDS agreement?
I am unaware of such loss and rather aware of the saving of a national asset which was unsecured, consequent on the failing of the demand guarantee.
Would you say that before the government entered into that contractual relationship, there was trust in public officials who ought to have conducted due diligence to avoid what eventually happened in respect of a termination.
I think that, as I indicated earlier on from the timelines, the due diligence was actually conducted promptly after the demand guarantee was issued. The demand guarantee was issued on 27 February 2018. And
my simple question is, was that a failure of due diligence to have been conducted by public officials entrusted with public trust?
It cannot be, because as I indicated, right after it was issued, the due diligence was conducted, and within about 2 or 3 months, the invalidity of the demand guarantee was ascertained. So there cannot be a failure of due diligence.
You serve on the PPA board. You've answered that. And you quoted a letter from the PPA and quoted extensively from Section 38A, reference to a letter by PPA. Did you take part in the meeting that eventually produced that letter?
Please, are you talking about the letter approving the Japa transaction?
Yes, you read that letter. You referenced Section 38A and went subsequent to refer to Section 39(1). And I asked you at that material time whether 39(1) was referred in the letter. And you say you were now speaking to it. Did you take part in the meeting which eventually led to the approval letter as representative of the Attorney General on the board of the PPA?
Chairman, I would not remember, because really many meetings, as I indicated, are held, and I would not remember at all.
So you are on the board.
Is 38(1)A. Even though the letter wrote 38A, the provisions should have been 38(1)A.
The Honorable Abdakwa, kindly give me your laws. The 38 doesn't have a 1, with all respect. Learned Deputy Attorney General. The Section 38 of Act 663 has no 1. It's just a 38ABC. So, I have a copy here, and I'll share mine with you. And Chairman, may I request that he has a copy of the mandate agreement. I'd like to have your copy for my purposes. Section 38 doesn't have a 1.
Mr. Chairman, the
I have 38A and B.
Mr. Chairman, the law has been amended, Mr. Chairman. And I think that you're not, this house amended the law. So there's now a Section 38(1) and a Section 38(2). And I have the consolidated version, because I'm a member of the PPA board. So you are misleading my papers. So, Mr. Chairman, that is why I said that the law was amended way back in 2016. It was amended in 2016 before this letter was written. So I have the current one, and I can give the House a copy.
Section 38, the Public Procurement Amendment of 2016. Is there a further amendment to the 2016?
Mr. Chairman,
no, let him answer.
No, Mr. Chairman, it is the same one which incorporated a subsection 2. So the law, Section 38 of Act 663, now has 2 provisions, Section 38(1) and Section 38(2). So, Mr. Chairman, I think that, and that was before, most importantly, that was before the letter was written. So I'm right in saying that the provisions have been 38(1). And I have the
Section 38(1).
Yes, 38(1)A. So I have the consolidated version.
Just read your act title. Is it Act 914? I have no difficulty conceding.
Yes.
I'm holding Act 914. Yes. I see a 38 in it. I don't see a 1. It has heading of parts 7 of Act 633 amended. So just share that with me to guide me. I have no difficulty conceding to you. Right. I have Act 914. Which act are you referring to? The number. Just give me your number, act number. As amended.
So Act 914 amended.
You are also referring to Act 914.
Yes, but the point I'm making is that Act 914 introduced an amendment which inserted a further subsection 2 into Section 38. And therefore, Section 38 of Act 63 should be construed to have two.
I'm fine. You are Attorney General. You are privy to it. Give me the date of Gazette of the one you are holding. I have 12 May 2016. So just share yours with me.
The Chairman is a consolidated Act 63. And in it, you see that
I concede to you. You recall, I concede to you.
I'm very grateful.
You referred to Act Section 38(1), yes, but further said that reference to 39(1) was not in the letter you referred to, which was issued by the PPA granting the approval. Is that right?
Yes, Mr. Chairman, that is right. And that's because Section 39 is a procedure.
Will you accept that was failure on your part because you serve on the board? The board will have benefited and ought to have benefited from your advice on this matter. The board issues a letter, and today you are expressing an opinion different from the board to which you participated in this meeting.
Mr. Chairman, it is not a failure, and the same will be done today, because the approval is given under Section 38(1)(a. And then the procedure after the approval has been given is for the entity then to have record.
So simply, was there reference to Section 39(1) in the approval letter you referred to?
Mr. Chairman, there was not, and there ought not have been.
Thank you. That's sufficient for me. And then, Chairman, let me now refer the nominee to the Special Prosecutor Act. And I've known and worked with the Special Prosecutor who resigned, and I know he's a very meticulous person with demonstrable fidelity to the law and patriotism to the country. Go to the mandate under Section 4(2), subject to Clause 4 of Article 88 of the Constitution. The office shall, for the purpose of this act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. Section 4(2)(1). So if you say that the Honorable Special Prosecutor could have just proceeded to court to prosecute, do you appreciate the provisions of Section 4(2) of the Special Prosecutor Act, in fairness to the Special Prosecutor?
I appreciate it, and indeed, pursuant to Section 4(2), the Special Prosecutor has had full authority to prosecute for corruption.
Did the Attorney General on this specific matter give him the authorization to proceed to prosecute this matter? That official correspondence on.
The Special Prosecutor has been given authorization to institute charges for corruption, and indeed it has exercised that power in numerous cases. The Special Prosecutor himself, in the report in question, alluded to the prosecution of the Boko Municipal Chief Executive Officer. That is pursuant to Section 4(2).
So no, I'm just saying, you said you had difficulty with him writing to the President and that he could have just taken the initiative to prosecute. Yes. And I'm saying that his power to prosecute is conditional respecting his mandate under Section 4 of Act 959 of 2017.
Mr. Chairman, he could not even just have prosecuted. He could have proceeded to first investigate before prosecuting, because there has not been any investigation at all. He himself indicated in his report that this report was not an investigation. Secondly,
that's appreciated. That's appreciated.
That's I think very important. Even if Section 4(2) is construed to mean that the Attorney General ought to give authorization for each case before the Special Prosecutor will prosecute, there has not been any investigation at all. There has not been docket built. And there has also not been any request for such authorization by the Special Prosecutor.
That's appreciated. Now on your ruling, I note that you've dealt with the matter sufficiently. Mandate agreement, I need your copy. The clerk, if you can help me have it. But first of all, it's important you appreciate, and you read, that the Office of the Special Prosecutor conducted a report on the analysis of the risk of corruption and anti-corruption risk assessment of the processes leading up to the request for approval and approval of the transaction agreement and tax exemptions granted by Parliament thereunder in relation to the gold royalties monetization transaction under the Minerals Income Investment Act 2018. You sought to trivialize the work of the Special Prosecutor by just referring to a mandate agreement and referring to Article 1815 and the judgment of the Supreme Court, and seeking to make a distinction between ordinary commerce and what you describe as non-major international economic transaction. Was the Ajapa royalties transaction international in your view?
By referring to the, Mr. Chairman, I think that first I must also correct the impression conveyed by the question that I sought to trivialize the work. I did not say so at all. I did not feel like the work. Transactions in the course of ordinary commerce, like letters of credit. So if indeed you enter into an agreement whereby a foreign bank is supposed to execute letters of credit on your behalf, are you going to say that that is a major international agreement? The court said no, and I construe this mandate agreement in the same vein.
Honorable nominee, I won't belabor it. You shared your opinion. I'm also just sharing my opinion. May I refer you to a letter you quoted and again captured in the Special Prosecutor Risk Assessment Report when you refer to a letter from the Ministry of Finance dated 6 October 2017, which was signed by Honorable Deputy Minister Charles Edu-Boahen. Now, if you refer to the Special Prosecutor, and this emphasis is mine, you mention some entities, Triple Flag, Navarra Capital Limited, Stanbic Bank, in that lane. These were the words of the Special Prosecutor. The absence of the name of Imra Corporate Finance from this list needs to be noted. Now, Imra later on, the relationship of $4 million US. Is that also major or minor?
The appointment of Imra Corporate as a managed agreement, I've stated time and again that it does not constitute a major financial agreement in the context of Article 181 clause 5.
You also
Mr. Chairman, I think that the omission of Imara Corporate Limited from the list that you indicated was really nothing remarkable, in the sense that the documents that were submitted, the application that was made to the PPA board, included Imara Corporate Limited.
My search reveals that as of October 2019, PDS, subsequent to the agreement government signed, was still in possession of some money of up to 3 billion Ghana cedis. Are you aware of it? And does the state have any resources to retrieve from PDS?
Mr. Chairman, I'm unaware. Mine is to deal with legal issues, and now I'm aware of a suit that has been filed by PDS against the Attorney General pending at the High Court of Accra.
While the agreement was pending, the PDS received some money, and would you be interested in finding out what has happened to that money?
Mr. Chairman, that will be within the remit of Minister for Energy. I can see my very good friend, Mr. Doctor. Doctor waiting for his turn.
May I now refer you to the 1992 Constitution? There are those who think that some provisions of it should be amended, some think that there must be a holistic constitutional review. In your view, I heard you on Article 11(7) requiring some amendment. You should be aware that it's part of the entrenched provisions of the Constitution, and you know what is legally needful and appropriate to do. But which aspects of the 1992 Constitution would you want to see reviewed?
I think that the circumstances of our time will definitely require a consideration of Article 78(1). So I think that it should agitate the minds of Ghanaians whether still find Article 78(1) relevant. I would recommend, even though it's again an entrenched provision, an amendment of Article 78(1) to remove the requirements on the President to appoint majority and the emphasis on majority of ministers from Parliament. I think that the President may appoint from Parliament, and he should be given a free hand. That is one major provision that I would think that the people of Ghana, apart from me, would require urgent amendment.
Thank you. May I also refer you to Article 131 of the 1992 Constitution and just seek your view on a particular matter. It is, an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court. And the opening words in 131A says, as of right, in civil or criminal cause or matter in respect of which an appeal has been brought to the Court of Appeal. Do you think that it must be an appeal as of right?
I think that the Chairman, well, as of right, could still be there. I think so. But the Supreme Court should have the power and should be able to exercise it effectively of managing appeals that they hear. Because the situation where the Supreme Court is flooded by so many cases, you go to court every day, and it's almost like the first court in the Superior Court architecture. It's not right. I think the Supreme Court should hear only serious matters, and the court should vet the appeals and other constitutional matters that they consider.
What will you do to improve relationship in enhancing the performance of the bar to facilitate the administration and speedy delivery of justice in Ghana when approved as Minister for Justice and Attorney General?
First, I think the lawyers ought to be candid. We have had an inundation of the Supreme Court with so many cases, Court of Appeal also with so many cases, because lawyers sometimes unjustifiably refuse to accept the outcome of cases that are adjudicated against them. I mean, when I was in private law practice, I could count the number of appeals that I got. Of course, with all respect and all humility, most of the time I succeeded because I pursued the right courses. But in cases, rare cases, that decisions went against me. It is only when I felt very much aggrieved or very justifiably aggrieved that I will pursue on behalf of my client. So to start with, lawyers ought to be candid. Even simple tenancy matters, they will appeal against the
Honorable,
I think that's wrong.
Nominee, we are asking what you will do. What the lawyers, you will be the leader of the battle, will deal with them, but how can you assist the speedy recovery of justice?
So, Mr. Chairman, I think that in line with that, perhaps continuing legal education ought to be enhanced, ought to be boosted. So I will support the efforts of the bar to ensure continuing legal education. I will also support lest I forget, earlier on in my response to the question about the Ghana Law School, I omitted the fact that the Ghana Bar Association itself has actually contributed an amount of money for the undertaking of the Law Village project. The Law Village project is about to start. The drawings are accepted, and the Ghana Bar Association has taken the lead by contributing a very significant amount of money. So, Mr. Chairman, I will join hands with the bar president to ensure that all that is required to boost the performance of lawyers in Ghana will be done.
Thank you, Chairman.
I'm happy that the bar president is here to support me today.
Thank you, Chairman. In your answer, when you referred to the Balkan Pharaoh Atlantis case and others, you emphasized heavily on Article 181(5) of the Constitution before sharing your opinion. For emphasis, let me, with the indulgence of Chairman, read. This article shall, with the necessary modifications by Parliament, apply to an international business or economic transaction to which the government is a party as it applies to a loan. We have acquiesced over this as Parliament, not just this Parliament. The executive have accused over this because I'm not aware of any modification. So beyond the Supreme Court ruling, what is your assurance that when you become Attorney General, you will give true meaning to the letter and spirit as expressed in Article 181(5) of the Constitution?
I said that it's a matter that I've considered for a very long time now, and it's something that is dear to me. I think I will really initiate legislation to give meaning to Article 181 clause 4, which requires an act of Parliament to be passed. Because really, the business community will stand to benefit from such an act of Parliament. The business community ought to determine, ought to be able to know which transactions ought to come before this Honorable House, and which transactions ought not to come. Maybe a time, international arbitrations are even fought on those lines. The government of Ghana, when it wants to resign from contracts, will then set up a defense. Oh, these agreements have gone to Parliament. And then it becomes a matter for international arbitration. I think that we ought to enact such an act of Parliament.
So the mandate agreement and the Japan monetized agreement, by your standing, does it qualify to be an international economic transaction?
Chairman, I've answered this question many times, and I will repeat that the original agreement, the gold royalties agreement, was an international business agreement and should have come before the House, and indeed it came before the House and was approved by this.
But the mandate agreement.
But the mandate agreement, I think that in international commerce, it ought not to have come. And it has not come.
That's your view. So you sought to dissociate yourself from your boss, the Honorable Gloria Akufu, on her opinion so expressed in those 3 letters that you referred to. Is that right?
No, Mr. Chairman, I did not. I said I stood by all the letters that
you said that,
and she never gave an opinion.
You said that she was not opposed to Ejapa. Should we expect Ejapa back? And in what form, character, and nature?
Mr. Chairman, that's the duty of the Minister of Finance. There are things that does not generate international economic transactions. We don't engage in that. We appoint our lawyers abroad to fight for the government of Ghana. That is all.
Chairman, I'm almost done.
I was going to announce.
We want to request that. No, all the documents he referred to, he should table them. Especially the mandate agreement. As Chairman, I requested that I wanted to make reference.
If all questions are exhausted, I can give the mandate agreements now.
Yeah, I needed it.
If your questions are exhausted.
No, but that, Chairman, I requested that I wanted to make reference to it.
Oh, okay.
Clerk, I did. You were here.
No, that's fine. I'm giving it to you. But I can give it to you if you are not asking any further questions. But this is my only copy.
And then finally, Chairman, we'll spend enormous time with you. Mine is Kodo versus Attorney General. You recall that on the District Assembly Common Fund, the Honorable Kodo and Richard Koshiga found some matter regarding the District Assembly Common Fund and its percentage. Ruling has been given. Do we have your assurance at Attorney? No, I just want to use it once before the copy. Do we have your assurance that you work with the Ministry of Finance to ensure that the ruling of the Supreme Court is respected in its entirety in ensuring that what truly is the deserving revenue of the Common Fund will be attributed to the District Assembly Common Fund?
That's what I do.
And then just in the news yesterday, everybody read data bank withdraws from a Japa deal. It was not data bank withdraws from a mandate agreement deal. So it tells you what role data bank probably played or was playing as book runners in the transaction. Now in the mandate agreement, you've just given me a copy. This is the title. Entered into by Ministry of Finance of the Republic of Ghana. Then it has Imra Corporate Finance Limited. Then it has Data Bank Financial Services Limited. So, Chairman, I just want our records to capture it. This is the mandate agreement.
Yes,
No.
All that already.
Oh,
he himself repeated them. All of
yes, I know. I'm referring to it now. And I'm just establishing that there is some reference to it to the Ministry of Finance representing the government of Ghana and to Imra Corporate Finance Limited. And in his view, this does not qualify as an international economic transaction by the provisions of Article 1815 of the Constitution.
I guess that's the end for the minority leader, the ranking member.
Yes, Chairman, but
thank you very much. After 6.5 hours I have the Honorable Deputy Attorney General.
Yes, sir.
There are some petitions brought to this committee. I've read them. None of them is alleging any specific misconduct on you. By you. One is by one Madame Frida Daku. She's saying that it is a case against her husband, but he tried to execute against her account. Why did you do that?
I think quickly, I will just indicate that the
Kindly be brief. We'll give you 6.5 hours of our time today to make the top crispy.
I'll make it very brief, and I'll quickly indicate that the case I did, or the cases I did, were actually against both Madame Frida Daku and her husband. Indeed, my client, the late Lene Iti Kwashi, had gifted a piece of land to his wife. The land is at East Legon, and the land was trespassed upon by Madame Frida Daku's husband. So my client's wife, a rate was taken out in her name. The case is Comfort Kokokwashi versus Yamenu. The judgment was given on 2209, 2nd July 2009. I have a copy of the judgment I can give to the committee. The committee will note that the judgment was entered in favor of my client after trial, and damages in the sum of 50,000 Ghana cedis 2009 were awarded. The chairman, after that, the defendant judgment debtor sought to set aside a judgment, and by another ruling dated 14 May 2010, the High Court dismissed the application. I have a copy of the judgment on the ruling. I can give it to the committee as well. Subsequently, we went into execution. I think even before we went to execution, the made under application so we went to execution, and the judgment, the certain accounts were attached. The chairman, Madame Frida Daku, indicated that her account has been erroneously attached. Indeed, the record will show that when she made this claim, I never disputed it at all. So the court actually gave a ruling dated 11 November 2010, releasing the account from attachment. And it's very important because the complaint seeks to suggest that I strenuously sought to attach the account and afford and all that. It says here that speaking to a motion or notice for self-exclusion, counsel for the defendant stated that plaintiff respondent has been served. He referred to a motion paper and the position in support, stated that the wife of the defendant was not part of the suit and is wrong to attempt to garnish her account, and that there is no judgment. So. The fact says that the motion has not been contested. So the record will show that when this was brought attention to the court, that her account has been attached, there was no contest at all. In all fairness to my practice, as I always say, I didn't contest. Can I say proceedings are maintainable with respect to the judgment debtor, and therefore in the absence of any contest, it was released. Chairman, that is that ruling of the court dated 11 November. Very well. Interestingly, Madame Frida Daku, after this, then filed a case indicating that she owned the land, the same land that we had gone to respect thereof. And the High Court on 7th March 2013 was a raised an objection and all. Madame Frida Daku filed an application for executory injunction. In opposition to the application for injunction, I raised an objection to propriety of the suit. The objection was dismissed. The court stated, in suit number so the plaintiff in this suit was not a party, but rather her husband was. If the plaintiff wants to set aside a judgment on grounds of fraud, then she should have done so in the name of her husband with his permission, or she should have sued the parties in that suit. The court then finally dismissed Madame Fidadapo's. It says in this case, the plaintiff had made some admissions above referred to and was not a party to the judgment letter. That's what the court set aside. Without coming by this new method of setting aside the judgment, in her capacity as a person affected by judgment, I will not only refuse the application for interlocutory injunction, but will also dismiss her action as an abuse of legal process. So Madame Fidadapo's action was dismissed again.
I brought the case and I said that there is no misconduct on your part.
Yes.
But there's a reason I brought it up.
Yes.
Because I want to announce that there are so many alleged petitions before us, yes, which are not alleging misconduct on the part of the nominees, but rather people have issues they probably think that this committee has the power to. There are some by trade unions, some by other people's employees who have issues with them. Those are private matters. So I'm putting it on record that I brought it up so that I'll get the opportunity to speak to that matter. But there's another one. They didn't say anything, but it's of public interest. Men's Gold aggrieved customers. They say he didn't take any action against Nana, Nana Mensah, is that his name? Why, as Deputy Attorney General, he didn't take action against Nana Mensah?
Gentlemen, I was not the Attorney General, and indeed, I don't recall ever handling a matter about Men's Gold when I was there. The reference to a petition was never addressed to me. There were two Deputy Attorney General. The other Deputy Attorney General, I remember, rather was assigned a brief respect of Men's Gold and actually went to Dubai in connection with it. So perhaps it's a case of mistaken identity. It could not be me. But
thank you. I think it's enough.
About Madame Fidadapo, it's a matter that is of concern. She has been peddling a lot of falsehood even before she came to this committee. The records will show, Madame Fidadapo, the records will show that she lost.
You're doing the same thing.
Yeah.
You have a problem with her elsewhere.
I'm just to show that she lost both at the High Court and the Court of Appeal. And came back to the High Court again. And
I know you're capable of defending yourself elsewhere.
Chairman, I just needed to, on a matter, I concede to him, but the Public Procurement Amendment Act 2016, Act 914, that I referred to and I'm holding, indeed, under Section 17, and it reads, Section 38 of Act 633 amended. Therefore, I have a difficulty accepting that I'm referring to a wrong act because it provides.
That's not right. You're not saying you're referring to a wrong act.
Okay, I appreciate that. So, my very last, but I just wanted to put that on record because the 38 here is not in tandem with what you have as consolidated. But just in an answer to a question to Honorable Suhuyini, the 35 other mining leases to which the Honorable Nobe and others have instituted action at the Supreme Court, you indicated that they have not been ratified by Parliament. And stretching the Ndebori decision, what steps will you take as Attorney General to control and stop the illegal mining of our resources by those entities that have not been ratified by Parliament? I thank you, Chair.
That's why I earlier indicated that I'm not aware of the specific circumstances of the various leases that were referred to. I know that the suit that was filed by my very good friend had various constitutional issues, and we raised objections to it, and the matter is pending before the Supreme Court.
Thank you for enduring us, for attending upon the committee. You are discharged. You will hear from us.
Everyone, very grateful. In the past, they would have made family members, they would people from Winchi and all that. I do not see that at this time. Is it a departure from the norm? Thank you very much.
The Honorable Minister for Energy nominee, Robert, the Crown of Bayentum. Okay, can you administer the oath?
I
Matthew Opoku-Prempeh,
swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue
touching the matter issue
shall be the truth.
shall be the